You are driving down the highway when suddenly the left rear wheel falls off your car and the car jolts to the ground, causing an injury to your back. A month later, you have surgery for a herniated disc. Although you have no medical insurance, you are confident that your medical bills will be paid. You bought an auto insurance policy from a company that promised to be your good neighbor, and the policy includes a promise to pay for medical expenses caused by an accident. That doesn't happen. 6 months after the accident, when your bills total $11,000, your insurance company sends you a check for $1,662. 18. You have to undergo a second surgery. The hospital won't let you have physical therapy after the surgery because you can't pay the hospital bill. You hire a lawyer, get more doctor's reports, and finally, 3 years after the accident, the insurance company pays you what it owed in the first place. It happened to Cindy Robinson. Her story is told in Chapter 7, and it could happen to you. A pipe breaks in the attic of your house, soaking walls, ceilings, carpets, and cabinets throughout the house. You need money to make repairs, and you expect that your insurance company, which sold you a deluxe homeowner's policy and promised that you would be in good hands, will come through for you. Instead, the company fails to adequately investigate the damage, looks for reasons to deny the claim, and refuses to pay for obviously needed repairs like the replacement of sagging, moldy drywall. Eventually, the company offers you a check for less than you need to pay for the repairs. Take it or leave it. You have to hire a lawyer and sue the company, and eventually, 5 years after the water leak, you recover enough to pay for your loss. It happened to Thomas Anderson. His story is told in Chapter 8, and it could happen to you. Consumers buy car insurance and homeowners insurance to be protected from financial disaster in situations like these. If you are injured in a car accident, you will suffer physical pain and emotional distress. If your house is inundated by water, you will undergo aggravation and inconvenience. No one can do anything about that. But if you have insurance, at least your insurance company will protect you from the financial consequences of the unfortunate events. That is why you buy insurance, to cushion the blow of accidents and injuries. Your insurance company pays for your medical bills, the repairs to your house, and the other expenses you are entitled to under your insurance policy. Too often, however, it doesn't work that way. The insurance company you trusted will delay paying for your loss, deny payment of part or all of your claim, and aggressively defend the lawsuit you are forced to bring to make the company live up to its promise. The reason is simple. The less the insurance company pays out in claims to you and people like you, the more it makes in profits. Delay, deny, defend is a violation of consumers' reliance on their insurance companies. It hurts people when they are at their most vulnerable, and it erodes the trust that all of us put in insurance. This book explores where and how delay, deny, defend occurs, why it has increased, and what can be done to stop it. Introduction. Insurance is the great protector of the standard of living of the American middle class. A good job provides the means to acquire a home, a car, a college education for the children, and a comfortable retirement, and insurance secures those things against the uncertainties of life. Houses will burn, but homeowners insurance furnishes funds to rebuild. Cars will crash, but auto insurance pays medical bills and repair costs and guards against potentially massive liability to other people who are injured. Illness, injury, and death will occur. But health insurance, disability insurance, and life insurance remove the burden of cost and replace the lost earnings of the breadwinner. Insurance has come a long way in 5,000 years, from the time when Babylonian merchants found investors who agreed to accept the risk of cargo lost at sea in return for a payment, a transaction that would develop into marine insurance. 1. Today, insurance in the United States is a trillion-dollar industry, with 2,700 property casualty insurance companies collecting $440 billion in premiums and paying $250 billion in claims each year. Property casualty insurance mostly protects against property damage and liability to others. Personal lines property casualty is largely auto and homeowners insurance, the subjects of this book. State Farm, the industry's giant, has 42 million policies in force and processes over 12 million claims each year. Insurance is the great protector of the standard of living of the American middle class. but only when it works. Purchasing an insurance policy is less like buying a product and more like receiving a promise. In return for the policyholder's payment of a premium, the insurance company promises to accept the risks of financial loss that the policyholder otherwise could not bear. As a formal matter, the promise to indemnify the insured against loss is embodied in the policy document, often 50 pages of 8-point type that is seldom read and less often understood, but the real promise is to provide security against loss. Long before the Gecko promised to save you 15% or more on car insurance, the iconic slogans of insurance company advertising expressed that real promise. Like a good neighbor, State Farm is there. You're in good hands with Allstate. Insurance doesn't work when the insurance company fails to honor the terms of the policy and its promise of security through the strategy that has become known as delay, deny, defend. The company delays payment of a claim, denies all or part of a valid claim, or aggressively defends litigation the policyholder is forced to bring to get what he is rightfully owed. When insurance doesn't work, the consequences are more severe than when any other kind of company fails to keep its promise. If a homeowner hires someone to paint his house and the painter never shows up, the homeowner can take his money and hire someone else. If the insurance company refuses to pay a claim, it is too late to go elsewhere for another policy. No company will write a policy that will pay for fire damage that has already occurred. Insurance didn't work for Kim Zilish, who was in an accident that killed her fiancé and permanently injured her. After she filed a claim with State Farm, her insurance company, the response was to delay. State Farm's claims adjuster knew her injuries were permanent, yet waited 4 months for a copy of a doctor's report he knew didn't exist. The adjuster then concluded, without sufficient evidence that Zilish's injuries were not that serious, waited another 4 months to make an offer to settle her claim, then changed the offer without regard to the facts. A year after her claim was filed, Zilish was awarded $387,500 by an arbitration panel, at which point State Farm finally paid the policy limit of $100,000. Two insurance didn't work for Terry Buttery. When his home was burglarized, he called the police and his insurance company, Hamilton Mutual. Buttery completed the claims forms he was given within 24 hours, but that was only the beginning. Even though he supplied 3 more statements, receipts for stolen items, repair estimates, and 5 years' worth of tax returns, and gave testimony to Hamilton under oath 4 separate times, Hamilton still did not pay. So Buttery sued and won. But Hamilton delayed payment even after Buttery's judgment was upheld by the Kentucky Supreme Court, hoping that his precarious financial position would force him to settle for less than he was owed. 3. Delay, deny, defend violates the rules for handling claims that are recognized by every company, taught to adjusters, and embodied in law. Within the vast bureaucracy of insurance companies, actuaries assess risks, underwriters price policies and evaluate prospective policyholders, and agents market policies. The claims department's only job is to pay what is owed, no more but no less. A classic text used to train adjusters, James Markham's The Claims Environment, states the principle. The essential function of a claim department is to fulfill the insurance company's promise as set forth in the insurance policy. The claim function should ensure the prompt, fair, and efficient delivery of this promise. Before beginning in the 1990s, many major insurance companies reconsidered this understanding of the claims process. The insight was simple. An insurance company's greatest expense is what it pays out in claims. If it pays out less in claims, it keeps more in profits. Therefore, the claims department became a profit center rather than the place that kept the company's promise. A major step in this shift occurred when Allstate and other companies hired the mega consulting firm McKinsey & Company to develop new strategies for handling claims. McKinsey saw claims as a zero-sum game, with the policyholder and the company competing for the same dollars. No longer would each claim be treated on its merits. Instead, computer systems would be put in place to set the amounts policyholders would be offered, claimants would be deterred from hiring lawyers to help with their claims, and settlements would be offered on a take-it-or-litigate basis. If Allstate moved from good hands to boxing gloves, as McKinsey described it, Policyholders would either take a lowball offer from the good hands people or face the boxing gloves of extended litigation. How widespread is delay, deny, defend? How often is it that insurance doesn't work? There are two answers: too widespread and too often, and no one knows. Too widespread and too often. As the new claim strategies have been implemented, there have been an increasing number of cases in which companies have delayed payment, denied valid claims, and unnecessarily defended litigation. Minor auto accidents have become the source of major litigation as companies routinely and systematically deny claims. Homeowners can no longer be assured of receiving enough from their insurance companies to rebuild their homes and their lives. When mass disasters strike, uh, things get even worse. After Hurricane Katrina struck in 2005, policyholders who believed they were treated unfairly by their insurance companies complained to the Louisiana Department of Insurance at the rate of $20,000 a month during the first 6 months after the storm. Thousands of policyholders sued their insurance companies. More than 6,600 suits were filed in federal court in New Orleans alone, and many cases are still pending. Nor is delay, deny, defend restricted to auto and homeowners insurance. All insurance companies have an incentive to chisel their customers in order to increase profits. Unum, the largest seller of disability and long-term care insurance in the United States, became notorious for failing to pay what it owed to sick or injured workers. Numerous courts castigated the company for unscrupulous tactics, nonsensical legal arguments, and lack of objectivity amounting to bad faith in denying claims. Employees who were especially aggressive in denying claims were recognized with the company's Hungry Vulture Award. Um, Under a settlement with insurance regulators in all the states, Unum was forced to review claims denied between 1997 and 2004, and it reversed its decisions in 42% of the cases, paying out $676 million in additional benefits. Almost everyone who has health insurance has a story about an arbitrary or incomprehensible denial of a claim. In 2009, New York Attorney General Andrew Cuomo concluded that the databases used by insurance companies to calculate the reasonable and customary fees they would pay for out-of-network treatment were part of a scheme to defraud consumers by systematically lowballing the fees. United Health, Aetna, Guardian, and other companies agreed to stop using the faulty databases and contribute to the creation of a new independent database. The story of delay, deny, defend by property casualty companies is part of the failure of insurance as a whole. No one knows how widespread delay, deny, defend is, because part of this story is the failure of state insurance regulators to police insurance companies' conduct. Insurance is the most heavily regulated industry in the United States. Every state has an insurance commissioner who licenses companies and agents, sets financial standards, requires regular reports, and examines the operations of companies. Most of the regulatory effort is devoted to making sure insurance companies have the resources to honor their promise to pay claims, and that effort works well. When insurance giant AIG collapsed in September 2008, its financial products division was a shambles, but regulators reported that its property casualty insurance company subsidiaries were sound. Making sure companies actually do honor their promise has received much less attention. Insurance commissioners generally do not even collect, analyze, and publish comprehensive figures on the payment and denial of claims. Consumers certainly do not know how widespread delay, deny, defend is for the industry as a whole or for individual companies. Consumers have little to go on when making one of their most important purchases, auto and homeowners insurance, to secure their standard of living. The average American homeowner pays $804 each year for homeowners insurance, about what she might pay for a new television set. Yet someone buying a television has many more sources of information about the product's performance and reliability than does the purchaser of homeowners insurance. Then Consumer Reports tests TVs in its labs and surveys hundreds of thousands of its subscribers. So a shopper can learn that a Sony TV has better picture quality than a Westinghouse and is about 3 times less likely to need a repair. But the insurance shopper has little accurate information on whether Allstate or State Farm is more likely to pay a claim. And information is even more important when buying insurance. If a TV is unreliable, it can be repaired or replaced, and the owner is at worst out the price of the set. But if an insurance company fails to pay a claim after a loss occurs, the consumer is out of luck. The story of delay, deny, defend is easy to understand but hard to discover and document. It is easy to understand that insurance companies make more money when they pay less out in claims. And as with other industries, from chain restaurants to internet sales, they have become more systematic about the ways in which they make money in recent decades. But while insurance companies like to shape the public's perception of them through advertising, they are notoriously unwilling to disclose information about their internal workings, especially information that shows they do not always deliver on their promises. Companies spend a great deal of money on advertising that they will fulfill their promise to provide security for their policyholders, but they also spend a great deal of money on lawyers to mask the times when that security fails. News articles, trade journals, industry groups, academic studies, and an increasing number of websites and blogs cover insurance companies and their claim practices. But this book depends on three special kinds of sources that insurance companies go to great length to keep under wraps or discredit. The first are insider accounts provided by former insurance company employees who have become whistleblowers. The second is information revealed in litigation against insurance companies. And the third is the documentary evidence of the redesign of claims practices to increase profits at the expense of policyholders and victims. Much of the evidence in this book is about well-known companies, State Farm and Allstate in particular, but it is not an attack on them. They are just the largest players in the industry, and the companies whose involvement with McKinsey and Company in the transformation of claims is the best documented. Traditionally, claims adjusters were taught to follow a simple maxim: we pay what we owe. The adjuster's job, to determine what the claimant was entitled to under the insurance policy, carried independence to exercise judgment and an obligation to assist policyholders in their time of need. As the claims department became a profit center and delay, deny, defend increased, the adjuster's job changed, diminishing the obligation to the claimant in favor of an increased obligation to the company's bottom line. For many adjusters, the change was disheartening. Robert Dietz, a 15-year veteran of Farmers Insurance, described the shift. My vast experience in evaluating claims was replaced by values generated by a computer. More often than not, these values were not representative of what I had experienced as fair and reasonable. 5. Many adjusters adapted to the new system and kept their jobs or were replaced by claims representatives, the customer-friendly term now preferred by the industry, who were trained in the new normal. Some, like Dietz, left their employers and revealed what was happening. The company's response has been, predictably, to try to silence or discredit the whistleblowers. Dietz became an expert consultant on claim practices, and farmers sued to obtain a gag order to prevent him from sharing his knowledge with lawyers representing policyholders. Farmers eventually abandoned the attempt to silence Dietz. 6. Other former employees have faced similar attempts to restrict them, but former insurance adjusters have become important sources for information about claims practices. Usually, when an insurance company delays, denies, or underpays a claim, that is the end of the story. The claimant might not understand that he has been shortchanged, or he may not believe that there is anything he can do about it, or he may just want to get on with his life. In some cases, however, the claimant sees that he has been wronged and believes that it is worthwhile to get a lawyer and fight for what he is entitled to. In the course of those cases, attorneys have discovered a great deal of information about insurance company behavior in the individual cases being litigated and about their general claims practices. Documents produced in discovery, testimony at trial, and reported judicial opinions provide major sources of information about how insurance companies organize and conduct their business and how it affects their claimants. Because litigation often drags on, it can take years for this information to come to light, and when it does, the companies disingenuously attack it as outdated. This evidence is seldom produced willingly. On the contrary, insurance companies expend considerable effort and lawyer time to limit the information produced and to keep what is produced out of the hands of those who should know about it. In numerous cases, they have quibbled, equivocated, concealed, and sometimes even defied the legal processes that aim to produce an informed adjudication of disputed cases. When company executives and claims supervisors are deposed, they are often unresponsive or difficult. An Oklahoma trial judge described State Farm's witnesses as obstructionist when holding the company in contempt for discovery abuse in 2007. 7. In a Nevada case in 2002, State Farm tried to block a policyholder's lawyers from introducing documents that the company argued were confidential, though they came from the public records of the Washoe County Court Clerk's Office. 8. Even when a plaintiff's lawyer discovers damaging evidence about claims practices, the company has a simple way to prevent it from ever becoming public: settle the case. In any case in which the plaintiff's lawyer discovers evidence that would be damaging in future cases, the company may conclude that it makes long-term sense to settle the case on the condition that the plaintiff's lawyer agrees to keep confidential any discovery material. The attorney is forced to agree because he must accept a settlement that is favorable to his client, even if it injures future claimants and the public at large by keeping the bad practices secret. In a case that is not settled, the company can still apply to the court for a protective order under which the plaintiff's lawyer can use the evidence in the current litigation, but not reveal it to anyone else. In particular, he cannot give the evidence to a lawyer representing a policyholder in another suit against the company in which it might be used to prove that the company consistently violates fair claims practices. If the court grants the protective order, as unfortunately happens too often, it is harder and more expensive for the policyholder in the second case to prove what may already have been established in the earlier one. Allstate went to especially great lengths in its attempt to prevent the release of the PowerPoint slides, notes, and training manuals prepared by McKinsey & Company when it was hired to redesign Allstate's claims processing in the 1990s. For critics of the industry, the McKinsey documents are the smoking gun that describes in detail how the claims process shifted from customer service to profit center. Allstate, in turn, contends the documents demonstrate its effort to make sure that each claim is promptly and fairly evaluated on its own merits. The documents were the subject of a 7-year odyssey through the courts that began in an ordinary lawsuit. Santa Fe, New Mexico, lawyer David J. Berardinelli, who would become Allstate's principal antagonist over the McKinsey documents, represented Jose and Olivia Pinchera in a suit against the company and its agents for bad faith denial of an insurance claim. After considerable procedural wrangling, Allstate gave Berardinelli a copy of the slides with an overlay that prevented them from being photocopied. Following 2 years of more motions and appeals, the appellate court upheld the trial judge's order to Allstate to produce the documents, and Berardinelli returned the overlaid slides and requested a legible copy. The company refused to give him one, essentially asking to be held in contempt of court so it could further challenge the trial judge's order on appeal. Lawyers in other cases sought to have Allstate disclose the documents, and it continued to resist with varying degrees of success. One Kentucky judge responded to Allstate's trade secrets claim by concluding that the material sought does not rise to the level of the Colonel's secret recipe. Because McKinsey had also consulted with State Farm, plaintiffs' lawyers sought similar documents in actions against that company too. The most remarkable case turned out to be a suit brought in Missouri by Dale Deere, who had been injured in an auto accident by Allstate-insured Paul Aldridge. The company was ordered to produce the McKinsey documents, and when it refused, Judge Michael Manners held the company in contempt and fined it $25,000 per day, beginning on September 4, 2007. Despite accruing fines eventually totaling $2.4 million, Allstate continued to refuse. The denouement of the saga came in Florida. On October 16, 2007, Florida Insurance Commissioner Kevin McCarty exercised his regulatory authority to direct Allstate to produce the McKinsey documents. When Allstate refused, McCarty suspended Allstate from selling new insurance policies in the state. When the courts upheld McCarty's authority on April 4th, 2008, Allstate immediately posted on its website 150,000 pages of the McKinsey documents that it long had argued were confidential trade secrets and essential to its business. 10. The point of view in this book is pro-consumer, but it is not anti-insurance. Insurance is essential to our economic security. But if insurance is to maintain its role as the great protector of the standard of living of the American middle class, prompt and fair claim handling has to be the rule. This book explores why that doesn't always happen and why it is even less likely to happen today than 15 or 20 years ago. 1. How insurance works. The world is an uncertain place. Bad things happen to good people and to bad people too. Houses burn down, cars crash, hurricanes devastate the coastline, pedestrians slip on ice-covered sidewalks, and in other ways, actual and metaphorical, lightning strikes. The bad things are usually unexpected, in part because people often assume, or at least hope, that bad things only happen to other people, not to them. In the language of insurance, the bad things that can happen, and sometimes the people or things they can happen to, are known as risks. The universally understood elements of risk are uncertainty and loss. The risk might or might not come to pass, but if it does, someone will suffer a financial loss. 1. The purpose of insurance is to ameliorate the financial consequences of risk by transferring the risk from an individual to a group and sharing the cost of the risks that come to pass among the members of the group. In this way, every insurance company essentially operates on the same premise as the oldest extant insurance company in the United States, the Philadelphia Contribution Ship for the insurance of houses from loss by fire. The Contribution Ship was founded in 1752 by a group of volunteer firefighters led by Benjamin Franklin. The risk of destruction by fire in colonial America was immense, so Franklin and his colleagues adopted the model of the Amicable Contribution Ship of London, founded in 1696, in which subscribing homeowners contributed specified amounts to be paid to those unfortunate ones whose houses burned. 2. The risk of fire loss was transferred from the individual homeowner to the contribution ship and shared among its members by their financial contributions. The contribution ship illustrates the concept of insurance in operation. A person is willing to exchange a small, certain loss, the payment of a premium, to avoid the potential of an uncertain but potentially larger loss, the cost of rebuilding a house. On the other end of the transaction is the insurance company, which is willing to accept the risk of the large, uncertain loss in exchange for the small, certain payment because it pools many such payments. This simple description encapsulates every insurance transaction, whether it is the everyday purchase of a homeowner's insurance policy or the acquisition of multi-billion-dollar commercial policies by Larry Silverstein, who, with exquisitely bad timing, acquired a 99-year lease on the World Trade Center in July 2001. The process by which the company assesses risks and accepts their transfer from policyholders begins with the accumulation of information about the incidence of losses. Before it issues auto policies, for example, a company wants to know for a given year, using 2007 figures, that 515 out of 10,000 drivers will have claims for property damage. There will be 21 fatalities in motor vehicle accidents for every 1,000 licensed drivers. A driver aged 21 to 24 is almost 3 times as likely to be involved in a fatal crash while legally intoxicated than a driver 55 to 64 years old. The average collision repair for all cars costs $3,131. The average collision repair on a Ford Focus costs 17% more than on a Honda Civic Hybrid, and so on. Actuaries sift and process this mass of statistical data to evaluate and define what kinds of risks the company might insure and at what rates. Drivers are classified and rated separately by age, gender, marital status, and driver training experience. Once the types of risks that will be insured are defined, underwriters establish the kinds of insurance policies that will be offered and the limitations on those policies, what will be covered, for what amounts, and to whom the policies will be sold. Then the marketers and agents go to work, advertising and selling the product, with the underwriters evaluating applications as they come in to ensure that they fit within the established guidelines. As is typically the case with corporate America, The economics that make this system work are simple in concept, but rococo in application. To remain solvent and to turn a profit, the insurance company wants to pay out less than it takes in. It takes in premium dollars from policyholders. It pays out on claims. The ratio between these two figures is known as the pure loss ratio. The property casualty industry as a whole in 2007 earned $451 billion in premiums and paid out $251 billion in claims for a loss ratio of 56. In other words, the insurance industry paid out to policyholders and tort victims 56 cents of every dollar the policyholders paid in. The industry's pure loss ratio has been improving over time, if improving is measured from the company's perspective. The loss ratio in 1987 was 67, and in 1997 was 61, which means that it has paid out a nickel less for every premium dollar compared to 10 years ago, and a dime less compared to 20 years ago. But paying out claims is not costless. Adjuster salaries have to be paid, computers have to be bought, and offices have to be rented. All of these costs are considered loss adjustment expense, LAE, or expenses that are directly related to paying claims. These costs are added to pure losses, the direct payouts, to get, obviously, the loss and loss adjustment expense ratio. For the property casualty industry, LAE in 2007 was $54 billion for a loss and loss adjustment expense ratio of 67. Then add to this all the other expenses the company has: salaries and expenses of the underwriting department, commissions to agents, the cost of the call center and Gecko ads, and overheads such as the IT department and the executive dining room to achieve the combined ratio. In 2007, these other expenses were $121 billion, yielding a combined ratio of 95. A combined ratio of less than 100 is good for the company. Considering all expenses, the company is taking in more than it is paying out. But even a combined ratio over 100 is not necessarily bad, because the company is taking in something else: investment income. The company pools policyholders' premiums to pay losses and expenses, but it does not simply hold the money until it needs to pay it out. It invests the money in the meantime, which is why insurance companies have been described as investment companies that raise the money for their investments by selling insurance. The time lag between taking in premiums and paying out claims, the float, and the income earned in that time is a major source of profit. In 2007, industry investment profits totaled $58 billion. As Warren Buffett, whose Berkshire Hathaway owns Geico and other insurance companies, has said, float is the great thing about the insurance business because it is money we hold that is not ours, but which we get to invest. For a company that can take advantage of float and also produce an underwriting profit, a combined ratio less than 100 has the best of both worlds. Buffett trumpeted in his folksy 2009 letter to shareholders that we were paid $2.8 billion to hold our float in 2008. Charlie Munger, Buffett's longtime partner, and I find this enjoyable. 5. In this way, an insurance company is like a bank, which takes in customers' money as deposits and lends that money out at a higher interest rate than it pays on depositors' accounts. The difference between the rate on loans and the rate on deposits, less the bank's expenses, are a bank's profit. Insurance companies have an advantage over banks, though, because their loss ratio can be less than 100. The bank depositor always gets back 100% of the amount deposited, plus interest. The insurance company with a pure loss ratio of 50 is only paying its customers 50 cents on the dollar. Even with higher expenses than the bank, with a combined ratio less than 100, the insurance company is ahead of the game even before its investment earnings. At some point, one of the unfortunate events that constitute the risks that were transferred from the insured to the company will occur. A car will crash, a house will burn, and an insured will file a claim. At that point, the fundamental truth about the claim process should come into play. When a loss occurs that is within the coverage of the insurance policy, the policyholder has already paid for the loss. The risk has been defined, priced, transferred from the insured to the insurance company, and shared by the company among its policyholders and investors, so all that is legitimately left to be done is to pay the claim. From the policyholder's point of view, the covered event should now be risk-free. That is, free of the risk that the company will fail to pay what it owes. The actuary's job is to evaluate risk characteristics, the underwriter's job is to evaluate potential insureds, and the executive's job is to manage the whole process. But the claims adjuster's only job is to decide if a loss falls within the policy, determine the extent of the loss, and pay the claim. Under life insurance policies, keeping the company's promise and paying what is owed usually is easy. The family sends in a death certificate, so the adjuster knows the insured is dead. The adjuster knows how much to pay from the face amount of the policy. All that's left to do is cut the check. Only in the most unusual cases is anything else involved. Rare are situations like that of Helen Gole and Olga Rutterschmidt, the hit-and-run grannies, two elderly ladies who took out dozens of life insurance policies worth a total of $2.8 million on homeless men Kenneth McDavid and Paul Vados, and then murdered them in staged hit-and-run accidents to collect the insurance. 6. The claim process in property casualty policies, on the other hand, can be more complicated. The definition of coverage under the policy can be Byzantine. A homeowner's policy covers all risks of sudden physical loss to the property. An exception excludes coverage for damage caused by water, and an exception to the exception includes coverage for water damage caused by sewers backing up. The facts that trigger coverage can be unclear. How much of the damage to a house struck by Hurricane Katrina was due to wind, covered, and how much to water, not covered? If an event is covered, the amount due may not be fixed. Uninsured motorist coverage pays for non-economic damages, such as pain and suffering, but there is no simple monetary measure of how much suffering a claimant has endured. No matter how complex in an individual case, a set of simple rules of the road of claim adjusting control the process. These standards are subscribed to by every insurance company. Allstate's goal remains the same: to investigate, evaluate, and promptly resolve each claim based on its merits, according to spokesman Michael Simienas. 7. Even when being sued by their policyholders, insurance companies acknowledge the rules. In a California case arising out of the Northridge earthquake of 1994, State Farm acknowledged its claim obligation is to operate its claim service in a manner so as to ensure that insureds receive all that they are owed, consistent with the facts of the loss and the language contained in its policies. 8. The National Association of Insurance Commissioners, NAIC, has promulgated minimum legally enforceable standards in its Model Unfair Claims Settlement Practices Act, a version of which is in effect in nearly every state, and judicial decisions in every state adopt and amplify the standards. The most basic rule is that in adjusting a claim, the company must not put its own interests above the interests of its policyholder. When a policyholder files a claim, she is invoking the promise of the insurance company to accept the risk and to provide security in the event of loss. That promise means that the company will not try to increase its own profit at the expense of the policyholder or to take advantage of the insured precisely at the moment when she is most vulnerable. Giving adequate consideration to the policyholder's interests means that the company must act promptly and must fully pay all legitimate claims. The NAICS Model Act requires a company to promptly and fairly settle claims in which liability is reasonably clear, to make its decisions about coverage within a reasonable time, to give reasons if it denies a claim, to maintain standards for investigating claims, and to be objective in investigating claims. It explicitly prohibits companies from making lowball settlement offers that force policyholders or accident victims to sue to recover the amounts they are entitled to. Industry standards and the law require companies to interpret provisions of the policy that establish coverage broadly and to interpret provisions that exclude coverage narrowly. In case of uncertainty, all doubts are resolved in favor of the policyholder and against the company, which wrote the policy and had the ability to draft it in a way that removed doubt. The company's obligation is even greater than being an independent adjudicator. The company has an affirmative obligation to help the insured with its claim. Insurance companies tout this role of aiding their policyholders. The State Farm website quotes Carmen Drake, an auto claims adjuster, who says, "I approach each customer's claim as if it were my own." That is, of course, what a good neighbor should do. The company must tell the policyholder about all the benefits and conditions of the policies. She should not have to hunt through the policy to find out what she is covered for and what pieces of paper she has to file to establish her claim within what time periods. A fair claim process is central to the insurance relationship because the policyholder is not just buying a run of the mill product or entering into an ordinary contract. She is obtaining security against an uncertain world. The Utah Supreme Court summed it up in the course of an opinion castigating State Farm for denying policyholders the benefits to which they were entitled. Insureds buy financial protection and peace of mind against fortuitous losses. They pay the requisite premiums and put their faith and trust in their insurers to pay policy benefits promptly and fairly when the insured event occurs. Good faith and fair dealing is their expectation. It is the very essence of the insurer-insured relationship. The insurance company's promise of security has real value, and people often understate its value. In a classic commentary in 1849, insurance entrepreneur D.R. Jacques wrote with respect to premiums, "The afflicted finds his money spent to some purpose, and only the fortunate part with it for nothing." 11. But that is wrong. The fortunate, those whose risks never come to pass and therefore never collect a penny from their insurance companies, spent their money for the purpose of security and peace of mind. Insurance companies market this feeling of security as much as they market individual policies. Be you're in good hands with Allstate. Nationwide is on your side. Like a good neighbor, State Farm is there. At Liberty Mutual, it's responsibility. A good neighbor is not a stickler for legal technicalities. A good neighbor picks up your newspapers while you are on vacation and doesn't complain if you don't return the cup of sugar you borrowed. More to the point, a good neighbor shovels the snow off your sidewalk if you are elderly and brings you soup when you are sick. Like good neighbors, your insurance company and you are bound by ties that law and profits cannot define. The insurance policy is a detailed contract, not just a vague promise of security, but it is a contract of a distinctive kind. Insurance lawyers sometimes speak of the four corners rule. The scope of coverage and the company's responsibilities are defined within the four corners of the paper on which the policy is printed. But courts have recognized that the relationship of the parties involved in an insurance contract is not fully captured in the printed words because it arises in a context and contains expectations created by advertisements, the sales pitches of agents, and common understandings of the role of insurance in providing security. Indeed, some courts disregard the express terms of the policy when they conflict with the reasonable expectations of the policyholder. In a famous case articulating this principle, the Iowa Supreme Court rejected the policy definition of the burglary of a store as requiring visible marks of forced entry on an exterior door, preferring instead an understanding held by the reasonable policyholder that burglary meant anything other than an inside job. Well, the insurance contract is also different from most ordinary contracts because it requires sequential performance. In a typical contract, if one party doesn't perform, the other party can procure a substitute performance and sue for any added cost. If a homeowner hires a contractor to renovate his house and the contractor fails to show, the homeowner can refuse to pay, hire another contractor, and if he pays the second a higher price, sue the first contractor for the extra. But if the homeowner has a fire and his insurance company fails to pay the claim, it's too late for the homeowner to buy alternate insurance. The best the homeowner can hope for is to sue the company for the coverage that should have been paid. But even that is not an effective remedy. The lawsuit does not give the homeowner the money needed to rebuild until the litigation is concluded, perhaps years later, during which time the homeowner has lost the security and peace of mind for which he contracted. Accordingly, courts hold insurance companies to a higher standard and subject them to special remedies if they fail to honor their promises. The promise of security extends beyond the relationship between an insurance company and an individual policyholder. For a long time, insurance in America was a community project, starting with the Philadelphia Contribution Ship. The original deed of settlement creating the contribution ship, still on display at its offices in Philadelphia, is a 44-foot-long parchment scroll containing the signatures and property descriptions of the original 1,774 subscribers, starting with Pennsylvania Lieutenant Governor James Hamilton and the first private subscriber, Benjamin Franklin. Beginning shortly after Wisconsin received statehood in 1848, several local insurance companies were formed to provide security for small town residents, just like the contribution ship, and to promote development in individual towns. Germantown Mutual, City of Waukesha Mutual, Cedarburg Mutual, Lakeland Mutual, and Menominee Mutual. Various lumbermen's insurance companies came several generations later. The Indiana Lumbermen's Mutual Insurance Company was founded in 1895 by the Indiana Retail Lumber Dealers Association to provide fire insurance to its members at reasonable rates. Eastern lumberyard owners formed the Pennsylvania Lumbermen's Mutual Fire Insurance Company the same year for the same purpose. Lumbermen's Mutual Casualty Company was organized in 1912 on behalf of lumber companies to provide the newly mandated workers' compensation insurance and to keep rates low by promoting safer workplaces. Its first manager was James S. Kemper, who would later give his name to the Kemper Insurance Companies, of which Lumbermen's became a part. Because these companies were formed by businesses and individuals to share losses, they were keenly aware of their responsibility to pay claims. Hartford Fire Insurance Co. was founded by a group of Hartford, Connecticut merchants in 1810 when fire posed a major threat to homes and businesses. After the Great New York Fire of 1835 destroyed hundreds of downtown buildings, including the New York Stock Exchange, 23 of 26 insurance companies in the city went bankrupt. Hartford's president, Eliphalet Terry, met his responsibility by driving a horse-drawn sleigh from Hartford to New York to personally pay policyholders' claims. 13. Even today, the Doctors Company Insurance Group promotes itself as founded by doctors for doctors. With some 43,000 physician members, the company writes $700 million of premiums each year. Beyond its primary function of providing liability insurance, it rewards participation with its tribute plan that accrues funds based on a member's premiums and pays benefits on retirement, disability, or death. The company also promotes the collective interests of its members by lobbying for proposals to limit malpractice liability and working to promote electronic medical records. What is striking about all of these efforts is that they are collective activities among groups of like-minded people and firms for their mutual benefit, thus the origins of the term mutual insurance company. These are not transactions between a self-interested insured and a distant corporate entity. They are rather joint enterprises among Philadelphia homeowners, Waukesha residents, Indiana lumber dealers, or practicing physicians. In that respect, they share origins and purposes with traditional savings and loan societies. Think of the Bailey Building and Loan Society from It's a Wonderful Life, not the SNL debacle of the 1980s, Landsmannschaften and other immigrant aid groups, and fraternal organizations that provide financial support for their members. In these entities, participation in insurance is a social activity that involves protecting oneself against calamity and a social responsibility as a member of the community to contribute for the benefit of fellows who might suffer a loss. Today, of course, most insurance is purchased through large companies rather than local organizations of coventurers. For collective activities conducted on such a large scale, the company is the necessary vehicle. Thousands or millions of insureds are involved, so a bureaucratic apparatus and the incentives of executive bonuses and shareholder profits are necessary to fund and motivate the enterprise. The core of the activity remains the same, however, collective action of all against the possibility of loss by some. The company acts as a fiduciary for the premiums pooled by all insureds and other like-minded people. The company profits from the transaction that is necessary to motivate it to act at all, but it owes the insured a duty to act to protect the insured's security. More broadly, insurance provides a social safety net for individuals and businesses, particularly for the middle class. Most Americans are only a car accident, a fire in the home, a lawsuit, or an injury away from having the wealth, the comfort, and the lifestyle accumulated over a lifetime of work wiped out. Insurance does not remove all of the consequences of a catastrophic loss, but it can make it something other than a catastrophe. 2. How insurance doesn't work. Insurance works when the insurance company honors a simple promise. When a policyholder files a claim, the company will pay what it owes, no more but no less, and will do so promptly and fairly. Insurance doesn't work when the company breaks its promise in order to increase its profits. Insurance doesn't work when companies delay, deny, defend. When they delay payment of claims to wear down claimants and to increase their investment income, flat out deny some valid claims in whole or part, and defend against valid claims in litigation to back up the delays and denials, they break their basic promise. Processing claims without delay is one of the basic claim practices required by law, stated in industry texts, and touted by every insurer. But delay helps the company's bottom line. The company keeps the premiums paid for longer and gets to invest those premiums and keep the investment earnings. Warren Buffett's crowing about the magic of float. Every dollar and every day that the insurance company fails to pay means more profits on the investment side of the ledger. Even a few dollars held for a few days on each claim add up when the company has thousands or millions of claims each year. More important, many claimants are vulnerable and need to be paid. An injured accident victim needs money for doctor bills and may be out of work. A homeowner, after a fire, wants to rebuild his house. Delay increases the pressure on the claimant to take what the insurance company offers so that she can meet her immediate financial needs and get on with her life. The longer the delay, the greater the pressure. Sometimes delay in paying a claim is simply stalling. Kim Zilish, an Arizona accountant insured by State Farm, was a victim twice, first of an auto accident and then of State Farm's delay. One after 3 exhausting days taking her CPA licensing exam, Zilish was returning home from a Billy Joel concert with her fiancé, Jeff Rosinski. While Rosinski drove, Zilish dozed off and awoke 2 days later in a hospital. A teenage drag racer had run through 2 red lights before smashing into the driver's side of the car, killing Rosinski instantly and crushing Zilish against the console and window of the car, injuring her permanently. Zilish recovered $146,500 from the drag racer's insurance company, but that amount was not enough to compensate her for her injuries. Fortunately, she thought, she also had her own insurance policy from State Farm that promised to pay her up to $100,000 if she was injured by a driver who did not have enough insurance to pay for all of her losses, called underinsured motorist coverage, typically paired with uninsured motorist, UMUIM, coverage to pay losses caused by a driver who has no insurance. State Farm's response was delay. A month after Zilish filed her claim, which included all of her medical and employment records, State Farm's claims adjuster, Scott Chan, met with her and then reported to his superiors on the severity of her permanent injuries. Chan then requested an additional report from a neuro-ophthalmologic surgeon with whom she had met, Dr. William Hoyt, who had not written a report because Zilish only saw him for a consultation. Nevertheless, Dr. Hoyt talked to Chan and confirmed that Zilish's injuries were permanent. Chan then waited for Dr. Hoyt's non-existent report for 4 months, despite having talked to him, received reports from 4 other physicians, and consulted another neurologist who agreed with Dr. Hoyt's diagnosis. Dr. Hoyt subsequently provided a written report, but Chan still concluded that Zilish's injuries had been fully compensated by the payment from the drag racer. State Farm required Zilish to be questioned under oath by State Farm's lawyers and ordered her to undergo another medical exam by its own doctor. Nevertheless, it made no settlement offer for nearly a year and never offered to pay the full policy limit of $100,000. A year after her claim was filed, Zilish was awarded $387,500 by an arbitration panel, and State Farm finally paid the policy limit of $100,000. Zilish then brought a suit against State Farm for bad faith in processing her claim, and the jury awarded her $460,000 in compensatory damages and $540,000 in punitive damages. At other times, companies delay by investigating a claim excessively, by pursuing more and more information that is not really needed for resolving the claim, dragging things out, and often exasperating the claimant into submission. Theodore Price's tortuous saga with his insurance company is an example. While at work on August 30th, 1995, he was struck by a car driven by Howard Wanderman. Because Wanderman's company ultimately denied coverage, on February 12th, 1998, Price's attorney notified his insurance company, New Jersey Manufacturers, that he would be pursuing an uninsured motorist claim. On March 18th, 1998, NJM asked for information about the accident and Price's workers' compensation claim. Fair enough. Then the delaying tactics began. In May 1998, NJM asked for more information about the workers' compensation claim. On October 8th, 1998, NJM asked for Price's medical bills. On April 20th, 1999, NJM demanded that Price be examined by a doctor of its choosing, which took place on September 14th, 1999. On January 15th, March 1st, and April 5th, 2001, Price's attorney sent NJM medical reports, employment records, a workers' compensation lien letter, and a medical authorization form. On August 21st, 2001, NJM asked for Price's complete workers' compensation file, the original MRI pictures dated December 20th, 1996, February 12th, 1998, and November 20th, 1998, and information on his employer's insurance policy. On September 20th, 2001, October 1st, 2001, March 27th, April 23rd, and September 27th, 2002, Price's lawyer sent more documents to NJM. Finally, on November 22nd, 2002, Price and his lawyer had had enough and filed suits seeking to compel NJM to arbitrate the claims. Too late, said NJM, because the statute of limitations expired 6 years after the accident on August 30th, 2001. The court saw through the delay strategy, however, and held that NJM's strategy had lulled Price into a false sense of security that the frequent contacts were enough to constitute filing a claim. As is always the case, that resolution did not come without its own delay. NJM's argument was rejected by the New Jersey Supreme Court and ordered to arbitration on March 10, 2005, almost 10 years after the accident. Two homeowners filing claims can suffer similar fates. When Terry Buttery's home was vandalized and burglarized, he immediately called the police and then his insurance company, Hamilton Mutual. Buttery completed and returned the claim forms Hamilton gave him within 24 hours. But that was not enough. Eventually, Buttery submitted what the court described as a vast amount of paperwork and documentation, including 3 proof of loss statements, all his receipts for the stolen or destroyed items, written estimates that he had obtained for the cost of repairs to his house, and his tax returns for the previous 5 years. He also gave testimony under oath to Hamilton 4 times and offered to have his accountant testify too. After a year of delay by Hamilton, Buttery sued, and the court awarded him $58,000. Hamilton then appealed to the Court of Appeals and then the Kentucky Supreme Court. Both upheld the verdict, but Hamilton still refused to pay. Not until Buttery threatened to proceed against the bond, Hamilton was required to post to appeal the case, did it eventually pay what the court said it owed, nearly 4 years after the loss. In Buttery's subsequent suit for Hamilton's bad faith delay, the reason for its conduct became clear. The investigation was not aimed at determining the amount of the loss, but at ways of avoiding payment. Hamilton had closely monitored Buttery's financial position, hoping his struggles and its delay would create leverage to make him take less than he was owed. And knowing that it was acting in bad faith, it intended to refuse to pay anything on the claim until Buttery released the company from future liability for its wrongdoing. Except in extreme cases like Buttery's, delay doesn't last forever. At some point, a decision has to be made on a claim. Fair claim practices require that the decision be made based on the facts of the individual claim, measured against the promises made in the insurance policy, independent of any considerations of financial benefit to the company. But as the New York Times editorialized, many insurance companies have turned denying valid claims into an art form. For denying valid claims in whole or in part is the logical successor to delay and the precursor to defensive litigation. After a company has delayed a decision on a claim, grinding the victim down and increasing investment profits in the meantime, the company's denial of payment of the amount owed forces the victim to either give up or be subjected to more delay, as the company can resort to an aggressive and extended defense of the claim in court. Tactics of denial have been colorfully referred to as lowballing and stonewalling. James Nelson, an attorney with extensive experience in insurance cases, testified in a 2008 Oregon case and defined lowballing as making minimal settlement offers to signal that the insurance company is willing to fight the claim and to lower the claimant's expectations, and stonewalling as refusing to negotiate settlement because claimants often have very limited resources and mounting medical and legal bills. Stonewalling puts psychological and financial pressure on such claimants. 5. In lowballing and stonewalling claims, companies may resort to unreasonable interpretations of the terms of the policy. Kristen Dine was struck by a car driven by an uninsured motorist and suffered a broken pelvis, nerve damage, and kidney failure. 6. Her initial expenses were covered by workers' compensation, but she contacted her auto insurer, State Farm, to claim benefits for other losses under her uninsured motorist coverage. Brandon Hill, State Farm's adjuster, told her that most of her claim was not covered, which was not true. That if State Farm paid her anything, she would only have to reimburse the workers' compensation insurer anyway. Also not true. And to boot, if she filed a claim, her insurance premiums would rise, which was not a great concern in the circumstance, since any potential increase in her premiums would be overshadowed by the amount of her lost wages of $26,603 and medical bills of $13,373. Soon after, State Farm's lawyer told Adjuster Hill that Dine was covered under her policy, but still State Farm did not pay. When Dine sued for her policy coverage, State Farm again simply denied liability despite its own attorney's advice. Companies may also resort to unreasonable interpretations of the facts to lowball and stonewall. Reagan Wilson was injured when a drunk driver made a left turn directly in front of her car. She suffered arm, neck, and back injuries and was treated in an emergency room, and she was later examined by her own physician and an orthopedist. After examining her and ordering x-rays and an MRI, the orthopedist concluded, a young woman involved in a high-speed motor vehicle accident with changes now in the cervical spine which are atypical for a patient of her age and are almost certainly due to the history of trauma. She probably has degenerative disc changes as a result of occult disc injury at the levels in the neck from her high-speed motor vehicle accident. Paul Le, the adjuster for her insurance company, 21st Century, formerly owned by AIG, since sold to Farmers, which is itself a subsidiary of Zurich Financial Services, entertained a different opinion for which he had no medical basis. In a memorandum to his supervisor asking for and receiving approval to deny her uninsured motorist claim, Lee wrote that Wilson has a pre-existing condition pertaining to scoliosis. MRI shows no encroachment of a neural structure. It is unlikely that the 2-millimeter bulge was produced by this accident. Only after Wilson's doctors recommended surgery did 21st Century order an examination by a doctor it selected, which confirmed the initial diagnosis and forced 21st Century to pay 2 years after she had initially filed her claim. 7. And when there are no facts to justify the denial, insurance companies may go looking for them. Investigation can take strange turns, even to what the popular insure blog calls stupid carrier tricks or insurers behaving badly. 8. Leandra Pitts was injured in a car accident near Atlanta and suffered a brain injury that affected her balance, memory, and speech. Because the other driver had only low limits on his policy, Pitts filed an uninsured motorist claim with Progressive, her own insurer. Because of the severity of the case, Progressive hired a private investigator, Merlin Investigations, to help determine whether Leandra's injuries really were severe. Standard tactics might include observing Leandra in public places to see if she exhibited the symptoms she was claiming continuously. Merlin went further. James Ferguson Jr. and Paige Weeks, Merlin's investigators, posed as a married couple and began to attend Southside Christian Fellowship, the church to which the Pittses belonged. The phony married couple pretended to be interested in joining the church and were invited to attend support sessions for church members held in the basement of the home of Ken King, a member and ordained minister. The sessions included confessionals about drug and alcohol addiction, abortion, sexual orientation issues, and other matters far removed from the question of Leandra's injuries. But Ferguson and Weeks secretly recorded the sessions. They did not discover any evidence that Leandra was faking her injuries, so Progressive eventually paid her claim. When the company's investigative tactics came out, the Pitzes and other church members were devastated. Progressive CEO Glenn Renwick refused interview requests but posted an apology online stating, "What the investigators and progressive people involved in that case did was wrong. Period. I personally want to apologize to anyone who was affected by this incident. We know that we were wrong in this situation and we take full responsibility for the mistakes that were made." Full responsibility had its limits, however. When Bill and Leandra sued for the invasion of their privacy, Progressive denied responsibility. Pursuing an insurance claim is like running a marathon or an obstacle course, and for those few who do not drop out or are diverted along the way, the final obstacle is a program of litigation that can wear down and defeat all but the hardiest. By forcing claims to litigation and aggressively defending it, insurance companies backstop the delay and denial of claims. The battle cry of the tort reform movement, in which insurance companies have played a prominent role, has been that there are too many frivolous lawsuits brought by too many greedy plaintiffs and too many ambitious lawyers. In fact, one reason there is a lot of litigation is because insurance companies force claimants to sue in response to delay, deny, defend. When claims are not paid promptly at their fair value, litigation is the only avenue for claimants to get what is owed to them, but it is not an easy path. For each claimant, having to resort to litigation increases the delay, cost, and aggravation of getting what she is entitled to. For all claimants, the knowledge that companies aggressively defend litigation provides a powerful deterrent to suing at all and increases the cost to victims and their lawyers. Forcing litigation brings the game to the insurance company's home court. For a policyholder, bringing a lawsuit is likely to be a unique and trying, no pun intended, event. But an insurance company, as Liberty Mutual once acknowledged, is a professional defender of lawsuits. 9, it should know, Chief Judge Edward Nottingham of the Federal District Court in Colorado described Liberty Mutual as a major league team in the game of hardball litigation. 10 acronyms tell much of the story. For some claims, the insurance company offers little or nothing, either because it contests liability or argues there is no damage. This is particularly likely for missed, minor impact, soft tissue claims, or what the industry likes to deride as whiplash claims. In auto crashes at slow speeds, minor impact, passengers are suddenly thrust back and forward, causing injuries that do not result in broken bones or other obvious trauma that readily appear on x-rays, but that can cause significant neck and back pain, soft tissue. Insurance companies often deny that a minor impact accident can cause a serious injury and either pay nothing or offer small amounts on a take it or leave it basis. Missed claims, discussed at greater length in Chapter 6, are particularly ripe for the defense strategy because the amounts involved are relatively small, typically a few $1,000s, but the expense of litigating the case, including hiring medical and biomechanical experts, can be substantial. The company often will spend much more in attorney fees and expert witness fees to defend a missed case than it would cost to settle it at the fair value. If the insurance company refuses to settle, few attorneys are willing to invest the time and money in a case in which their fee is not likely to justify the expense, so the injured victim cannot pursue the claim. In missed and other denial cases, the insurance company's key concept is SFXOL, settle for X, amount, or litigate, where X is likely to be the amount set for the plaintiff's claim by a computer system. The company will not depart from X, the predetermined amount, so if it is not a fair offer, then the claimant has no choice but to litigate. Realistically, as claimants' attorneys usually say, the acronym stands for settle for X, or with the else being the threat of litigation. And litigation in this context can be even more painful, protracted, and expensive than the ordinary lawsuit. The approach is DOLF, Defense of Litigated Files, which means defend to the teeth, with protracted and intrusive discovery, an extended pretrial process, occasionally a settlement on the courthouse steps, but just as often an expensive trial. Stonewalling in litigation, refusing to pay what is owed in the hope that better facts will emerge, or the claimant will be ground down by delay and will accept less than a fair settlement, is the logical complement to stonewalling in the denial of claims. Consider the strategy used by Farmers Insurance against the estate of Mark Goddard in a 2008 case from Oregon. Goddard was killed when his car collided with a truck driven by John Munson and owned by Helen Foley. Munson made a left turn into a parking lot and collided with Goddard's car, which was in its proper lane and had its headlights on. Foley and Munson told the police officer at the scene that he had permission to drive her truck. Munson's blood alcohol level was twice the legal limit, which was not surprising since, as he later admitted to Farmer's adjuster, he had had 8 to 10 beers before the accident. Both Munson and Foley were insured by Farmers Insurance. 11 Sellers, the farmer's representative, concluded that Munson's liability for the collision was clear, but he suggested, "I feel we should let things ripen a bit before making any settlement talk." Ripen they did. Even as Munson was convicted of manslaughter, farmers received an accident reconstruction report confirming that Goddard had been going at the speed limit when Munson turned in front of him without using a turn signal, and the state police confirmed that Goddard's headlights were on at the time of the accident. Throughout, Goddard's family's lawyer offered to settle the case for the policy limits. Farmers' refusal to settle surprised even Munson's criminal lawyers in light of Munson's manifest criminal liability and the possibility of a verdict beyond the policy limits, for which Munson personally would be responsible. A month after Munson was convicted of manslaughter, the attorneys hired by Farmers for the civil action filed an answer in court denying that Munson had been drunk and that he had caused the collision. Farmers refused to settle for the $200,000 in part because it believed only one of the policies applied to the accident, a position that was ultimately vindicated. Subsequently, the plaintiff's lawyers offered to settle for the $100,000 coverage under the applicable policy, but Farmers continued to offer only $30,000. Shortly before trial, Farmers' lawyers hand-delivered to Farmers a letter concluding that the case has a reasonable jury value between $75,000 and $150,000 for non-economic damages plus punitive damages. Strangely, later that day, perhaps in anticipation of a bad faith claim, the lawyers retrieved that letter and replaced it with a letter that deleted the amounts $75,000 and $150,000 and substituted a much lower range of exposure, $35,000 to $60,000 for non-economic damages. Both estimates were low. The jury returned a verdict for $188,274 in economic damages, $425,000 in non-economic damages, and $250,000 in punitive damages, a total of $863,274. Then came the suit against Farmers for its bad faith stonewalling of the claim. In that litigation, based on expert testimony that Farmers' stonewalling violated Fair Claim Practices standards, Farmers was found liable for punitive damages of $2.7 million. Beyond stonewalling is the full court press of delay, deny, defend, what the United States Court of Appeals for the Fourth Circuit called the fight and delay approach in a case brought against Kentucky National Insurance Company. 12 Leslie Joe Nance was driving his employer's tractor trailer on U.S. Route 25 in Barberville, Kentucky, when Lisa Cordell ran a stop sign and pulled out directly in front of him. Nance slammed on his brakes and swerved to the left, trying to avoid Cordell, but his tractor trailer jackknifed. Police officers arrived on the scene within 4 minutes, and their investigation concluded that Nance was traveling at the speed limit of 55 miles per hour, as confirmed by his truck's onboard computer, and was without fault in causing the accident. But Cordell's car windows were covered with frost that prevented her from seeing Nance's truck, and she failed to yield the right-of-way. Because of the accident, Nance suffered serious injuries to his head, neck, shoulder, back, and brain. His injuries required back surgery and other extensive treatments, and they left him out of work and unable even to do chores around his farm or enjoy family activities. Cordell was uninsured, so Nance filed a claim under his uninsured motorist coverage with Kentucky National. Nance's attorney faxed the police report establishing Cordell's liability to Kentucky National. Nevertheless, it refused to pay on the policy and instead created what the federal court described as bogus issues in an effort to delay payment, deny liability, and eventually defend against Nance's suit. Kentucky National claimed, without any evidence, that the brakes on the tractor trailer were defective at the time of the accident. Also, without evidence, the company accused Nance of speeding, an accusation that it gave up when the truck's onboard computer proved otherwise. The company hired an accident reconstruction expert to demonstrate that Nance caused the accident, but even that expert agreed that Nance was blameless. Nance had been treated by over 20 doctors and had voluminous medical records, but Kentucky National forced Nance to undergo a medical examination by its own doctor. Nance asked that the company use a doctor close to his home because his medical condition made travel difficult, but the company insisted that he be examined by a doctor in Lexington, Kentucky, a 2.5 hour drive from his home. After the 2.5 hour trip, Kentucky National's designated doctor examined him for all of 8 to 10 minutes. As Nance and his wife, Deborah, left the doctor's office, they realized that someone was following them and became frightened. At trial, Deborah testified about the events. Well, we had parked in a parking garage, and when we pulled out of the parking garage, we just looked back in the mirror and we noticed there's a guy. The car behind us has a video camera up to our car, and we thought, that's kind of weird. A guy in a parking garage filming somebody. So we pull out of the parking garage. The guy proceeds to pull out with us. We make a right. He makes a right. He has still got that video camera. Me and Joe start to think there's something weird. Something is weird about this. So we had to get on 64 to come home. So we get on 64. This brown car gets onto 64. The guy is still filming us. We change lanes. He changes lanes. We get faster. He gets faster. At trial, their suspicions were confirmed. The guy was a private investigator hired by Kentucky National. After a 1.5 years of discovery, during which Kentucky National refused to discuss settling the case, Nance's attorney tried to move the case toward trial. Kentucky National instead asked the court to schedule a mediation session. What followed was not mediation but more harassment. Nance, his wife, and his lawyer traveled over 3 hours to attend the mediation session, but Kentucky National refused to make a settlement offer and unilaterally cut the session short. Experts valued Nance's claim at between $750,000 and $1.3 million, but Kentucky National did not make a settlement offer until 3 years after Nance filed suit against them, 2 weeks before the trial date, and then only for $25,000. A week later, it raised the offer to $35,000 and then to $50,000. On the eve of trial, Kentucky National raised its offer to $60,000, and Nance was forced to capitulate. Kentucky National's tactics had put the Nances in dire straits. They had had to remortgage their house, sell farm equipment and even their hunting dogs, drain their personal savings accounts and their son's college fund, and hold yard sales to make ends meet. As Nance said in accepting the offer, Kentucky National had finally beat me down. And it turned out that Kentucky National's treatment of Nance was not an isolated case, but part of a pattern by the company. Kentucky National policyholder James Garland was injured when his car was struck by another car driven by a drunk driver who had just stolen gas from a convenience store and was speeding down a busy street and crossing the center line. As with Nance, Kentucky National denied the underinsured motorist claim, fabricated an argument that Garland was at fault, and offered to settle only on the eve of trial. Joe Holstein was a passenger in a car crashed in a single-vehicle accident by a Kentucky National insured who was speeding. Kentucky National offered Holstein substantially less than even his documented medical bills to settle his claim, forced him to file suit, and finally offered to settle only on the eve of trial. Based on this pattern, when Nance sued Kentucky National again, this time for violating the claims practices rules of the road, the court imposed punitive damages of $850,000 on Kentucky National. Delay, deny, defend is so common that lawyers have plenty of stories to tell. One plaintiff's lawyer described a case in which the insurance company claims representative announced that even if a verdict higher than the multi-million-dollar offer was returned, the company could delay payment indefinitely with the appellate process, and there was no telling when our client would ever see any money. Another reported on something weird happening at a major national insurance company, in that it was almost impossible to settle cases with them, forcing litigation in almost every case. One might expect these tales from plaintiffs' lawyers, but even defense lawyers report this type of behavior among their insurance company clients. Professor Herbert Kritzer interviewed many of them. One insurance defense lawyer, he writes, expressed frustration to me after a no fault arbitration hearing about handling cases where the insurer had no good defense. The lawyer believed that the insurer had made a business decision to fight such cases as a means of deterring certain classes of claims, even though the insurer should have known that the claimant who persisted with such a claim would prevail. Another lawyer described a case the insurance company required him to defend as a virtual sure loser. 13 delay, deny, defend is so frequent that it is even possible for a policyholder to buy insurance against the risk that the insurance company will deny a claim. Insurance broker Sweat and Crawford offers claims dispute insurance on behalf of NAS Insurance Services and Lloyd's of London. We know that wrongful coverage denials occur in our industry, said Sweat and Crawford Managing Director Jason White. Insurance against wrongful denials is needed because businesses that are wrongfully denied coverage by their insurers often cannot find lawyers to take their cases. Even simple cases can cost $50,000 to litigate, and complicated cases twice that, making litigation financially impractical. 14. These examples could be multiplied from litigated cases and media reports. ABC News' Primetime, NBC's Dateline, the CBS Evening News, Bloomberg Markets Magazine, the Detroit Free Press, the New Orleans Times-Picayune, Kiplinger Magazine, Money Magazine, and others have done exposés of bad faith claim practices. The industry, of course, dismisses the cases described as exceptional and decries media reports as biased and unreliable. When Bloomberg Markets Magazine exposed State Farm's use of the delay, deny, and defend strategy, the response from the company's public relations spokesman was predictable. The evidence was nothing more than anecdotes and a handful of lawsuits, most of which are routinely peddled by the trial bar to the news media. 15. The problem is bigger than that. It is not just a handful of lawsuits and, even more important, claims that should turn into lawsuits but do not. But how much bigger than that? No one knows. More precisely, no one knows except the insurance companies, and they're not telling. One obstacle to knowing the true extent of delay, deny, defend is the process that sociologists cleverly call naming, blaming, and claiming. If a consumer is chiseled, stonewalled, or otherwise mistreated by her insurance company, she has to identify herself as the victim of a wrong, naming, attribute that wrong to the insurance company, blaming, and then do something about it, claiming. Most of the time, that does not happen. The consumer may not realize that an event is covered by her insurance policy. If she does and contacts her insurance company, the company's behavior may seem normal or appropriate, so she will not think to file a complaint or bring suit. An auto policyholder files a claim for car damage caused by an accident. The company pays the costs of repair, but does not advise the policyholder that she is entitled to be compensated for a rental car. The company-affiliated repair center bases the estimated cost of repair on a visible inspection, but doesn't do sufficient investigation to reveal hidden damage to the frame. The company takes a long time to pay, or the company offers the policyholder less than the full value of the claim, asserting that that is all the claim is worth. In all of these cases, the insured may not know the company has breached its obligation under the policy and violated the law, so she accepts the insurance company's decision. Even if the policyholder feels that the insurance company has acted improperly, she may not know that redress is available through the state insurance department or the courts. If she does know, she may believe that it's too much trouble or unlikely to be worthwhile. Often, companies are not required to advise insureds of their right to file a complaint, and it may not occur to consumers on their own. And in many cases, the policyholder will not consult a lawyer, particularly in smaller cases or where insurance companies actively discourage insureds from asserting their rights. A few policyholders make it over these hurdles and complain to their state's insurance department. Some insurance departments and the National Association of Insurance Commissioners, NA, publish figures on complaints filed, but they fail to portray an accurate picture of the problem. Law professor and NAIC consumer representative Daniel Schwartz accurately characterizes the data as overlapping, confusing, and ambiguous. 16. The states and the NAA define categories that are impenetrable. There are complaints by consumers that are different than mere inquiries. Some complaints are confirmed by the department and others are justified or just closed. Sometimes the company takes corrective action and sometimes there are other outcomes. With these definitions, it is impossible to make much sense out of the numbers that are published. In 2008, for example, the California Insurance Department rated State Farm, the largest auto insurer in the state, as having the sixth best complaint ratio in the state, with just under one justified complaint for every 100,000 vehicles insured. Kemper Independence Insurance topped the list with no justified complaints, and Lincoln General Insurance was at the bottom with 17.6 justified complaints per 100,000 vehicles. That sounds good for State Farm, but there is more. Beyond the 28 justified complaints, it had a total of 669 closed complaints. Corrective action, including a compromise settlement by the company, was required in 97 more cases, and 307 had other outcomes. But the appropriate baseline for measuring the volume of complaints is not the number of insureds, but the number of incidents of loss. A driver who never has an accident has no reason to complain. About 1 out of 100 drivers in a year files a claim involving bodily injury, and 5 out of 100 file a claim for damage to the car. 5% of State Farm's 3 million insured drivers in California means 150,000 policyholders filed a claim. If there were 669 complaints, State Farm's ratio of complaints drops to 1 in 224 who made it through all the filters to complain to state regulators. One thing that is clear from the numbers is that when consumers complain, their most common complaints are about improper claim practices. Nationally, of all complaints filed with insurance departments, delays in processing claims account for 19% of the complaints, denials for 18%, and unsatisfactory settlements or offers to settle for 14%. The ultimate step in claiming is suing an insurance company, and a measure of the incidence of delay, deny, defend is the number of times policyholders and others are forced to sue companies to get the benefits to which they are entitled. Insurance companies certainly are frequently sued for violating fair claim practices, but they closely guard data on those suits. A rare instance in which one was forced to reveal how often it was sued was in an Oklahoma case against State Farm, the country's largest property casualty insurer, in 2001. Its lawyers were required to produce a list of all cases pending against it for violation of fair claim practices. What was unusual about the disclosure was that it was not subject to a protective order or confidentiality agreement. Ordinarily, insurance companies disclose such information grudgingly, and then only if the plaintiff agrees or the court orders that the information not be communicated to anyone else. The result was a computer-generated list 4 inches thick with 807 pages of 6-point type. It includes 4,706 causes of action brought by 3,237 separate policyholders and claimants, most filed within the year or two before, but some dating back 7 years and more. The number of cases brought varied widely from state to state, depending on the number of policies State Farm had in force and the strength of the state's laws protecting policyholders. Texas, for example, saw suits by 1,163 policyholders. California had 258, West Virginia had 162, and Pennsylvania 159. The reported figures of consumer complaints and the even more rare numbers on suits filed, limited and unreliable though they are, indicate there is a problem. It would be easy to get better figures, and the best evidence of the problem of delay, deny, defend is that better figures are not available. Companies could report on how many claims are filed with them, how long it takes to process the claims, how many claims are denied, how many policyholders have to resort to suing the companies to have their claims satisfied, and how those suits turn out. They could report the information to state regulators or use it in their advertising. Then the scope of the problem nationally would be easy to determine, and consumers would know who the worst offenders are. In fact, some states require insurance companies to report these numbers, and the NAAC has begun to collect the data. But the reporting and collection are secret at the insistence of the insurance companies. If they wanted to refute the existence of delay, deny, defend, they could do so. Their silence speaks louder than any numbers. 3. Moral hazard, the bottom line, and the origins of delay, deny, defend. Insurance works when insurance companies pay claims promptly and fairly. But there always has been a problem with this principle, the problem economists label as moral hazard. In the 19th century, insurers began to label as moral hazards those in which the occurrence or magnitude of a risk was increased by people of bad character. In the 1960s, neoclassical economics adapted the concept to fit with its emphasis on incentives. While studying the role of insurance in healthcare, Nobel Prize-winning economist Kenneth Arrow used it when he hypothesized that people with insurance would be more likely to consult doctors and more likely to use expensive medical procedures, increasing the cost of insurance and healthcare. One other economist criticized Arrow's use of the value-laden term, arguing that moral hazard has little to do with morality, but instead was a rational response by the individual to the presence of insurance, even if it would have detrimental effects for the community as a whole. 2. But Arrow, in a lesson that insurance companies could take to heart, argued that morality and economically rational behavior are not independent. Judas turned a profit by betraying Jesus. But even economists could argue that the behavior was blameworthy. One of the characteristics of a successful economic system, according to Arrow, is that the relations of trust and confidence between principal and agent are sufficiently strong so that the agent will not cheat, even though it may be rational economic behavior to do so. In a principal and agent relationship, one party has freedom to act in a way that will affect the other. The steps an insured takes to avoid or minimize a loss, or not to do so, affects the insurance company. On the other hand, how the company responds to a claim affects the insured. When the insured submits a claim, the insurance company has an incentive to delay, diminish, or deny the claim for the simple reason that it gets to keep the money unless and until it has to pay the insured. Therefore, the company is subject to moral hazard too. The history of insurance demonstrates regular instances of insurance companies succumbing to the moral hazard of not paying valid claims. In the 19th century, life insurance companies often refused to pay death benefits, arguing that the insured had misrepresented his physical condition when applying for the policy, which rendered the policy void. The companies required voluminous but vague disclosures on the application for insurance to set up the misrepresentation argument. In the 1870s, among the 16 questions Connecticut Mutual Life Insurance Company asked its potential insureds were the following. Have you ever had any of the following diseases? Answer, yes or no, apoplexy, paralysis, insanity, epilepsy, habitual headache, fits, consumption, pneumonia, pleurisy, diphtheria, bronchitis, spitting of blood, habitual cough, asthma, scarlet fever, dyspepsia, colic, rupture, fistula, piles, affection of liver, affection of spleen, fever and ague, disease of the heart, palpitation, aneurysm, disease of the urinary organs, syphilis, rheumatism, gout and dropsy, scrofula, smallpox, yellow fever, and cancer or any tumor. Have you had any other illness, local disease, or personal injury? And if so, of what nature, how long since, and what effect on general health? Is there any fact relating to your physical condition, personal or family history, or habits which has not been stated in the answers to the foregoing questions and with which the company ought to be made acquainted? 4. If any of the answers were incomplete or incorrect, the company later would assert that the misrepresentation voided the policy and the company didn't have to pay. August Baumgart, for example, was presented with a similar application that inquired about 37 diseases. He failed to disclose that he had been treated once for diarrhea and apparently piles, a listed disease. The failure was understandable. The trial judge found that Baumgart never knew he had piles. No matter, said the Wisconsin Supreme Court, and no matter that the illness did not contribute to his death from pneumonia. The insurance company could seize on the unknowing error to refuse to pay. 5. As a result of these abuses, some companies began offering policies with incontestability clauses. After a period of time when the policy was enforced, the policy would become incontestable for mistakes or misrepresentations in the application. That is, the company could not refuse to pay because of the mistake or misrepresentation. The market advantage to these companies was insufficient to control the abuse, however, and state legislatures responded. Ohio enacted a statute in 1873 providing that after an insurer had received 3 premium payments, it could no longer deny payment because of such misrepresentations. In 1906, New York's Armstrong Commission investigated widespread fraud and abuse by insurance companies and recommended modern incontestability legislation. And in 1946, the National Association of Insurance Commissioners recommended model legislation that was adopted in most of the states. 6. Life insurance companies succumbing to the moral hazard of manufacturing misrepresentations to avoid paying claims was common but ultimately obvious and easily controlled. Delay, deny, defend is different. It arose as a strategy in the mid-1990s because of unusual pressure on insurance companies' profits from the insurance underwriting cycle and a number of catastrophic events. Then it was fed by the new corporate culture that worshipped growth and profit and by intense price competition. At its core, it involves more than cheating customers here and there. It transforms the claims process into a profit center. People in business are supposed to act rationally in pricing and selling their products. Insurance companies don't. In alternating cycles over time, they sell a lot of their product at low prices and then sell less of their product at high prices. The high prices attract competition that drives prices down, starting the cycle over again. In a soft market, companies compete to sell more insurance. They relax underwriting standards and cut premium rates, so they sell more policies and riskier policies at lower prices. The inevitable result is that even though total premiums increase, claims rise too, and as claims rise, profits decline. When profits decline, the shortfall has to be made up from the company's capital surplus, so the capital needed to back up new policies is depleted. To compensate, the companies tighten underwriting standards and raise rates, so less insurance is available but loss results are better, a hard market. Profits rise and new capital is attracted by the higher profits, so the capacity to underwrite more policies increases, starting the cycle over again. 7. The pressure to cut premium rates would be peculiar, but understandable even if lower premium rates produced lower profits, but the fact that underwriting losses are not the whole story makes the behavior more logical. Premium dollars collected become funds for the insurance company to invest, and the expected return on those investments helps determine how much it is worth to accumulate those dollars, even at the expense of higher claims costs. When investment returns are high, companies engage in cash flow underwriting, or underwriting designed less to produce a gain on the ratio of premiums to claims and more to produce funds to be invested. Most insurers invest the bulk of their assets in bonds. For property casualty insurers as a whole, about two-thirds of their investments. Industry giant State Farm and Geico, the investments of which are managed by Warren Buffett as part of Berkshire Hathaway's portfolio, are the exceptions, with twice as much of their assets in stocks as most insurers. 8. Therefore, interest rates affect returns greatly. Higher rates mean greater returns, and that fewer assets have to be set aside now to cover claims to be paid in the future. Conversely, when interest rates fall, the lure of more premiums is less attractive, and there is less incentive to cut prices to grow revenue. Insurance underwriting cycles usually follow 4 to 6 year patterns. Starting in 1988, however, the pattern was broken by an unusually extended soft market that ran from 1988 until 2000. Underwriting losses for the industry were $10.2 billion in 1987 and $11.8 billion in 1988, then nearly doubled in 1989 and 1990, jumped to $36.3 billion in 1991, and never fell below $17.1 billion for the next 5 years. This extended soft market put company profits under unusual pressure. The pressure was particularly pronounced in auto insurance. 9. Nine, the All Industry Research Advisory Council, now the Insurance Research Council, conducted an extensive study of auto claims in 1987 and concluded that the cost of injuries rose 140% over the previous decade. That was more than half again the rate of inflation, with much of the increase driven by rising medical costs. At the same time that the underwriting cycle and rising medical costs were cutting profits, Mother Nature intervened and made things worse. A series of natural disasters increased losses and therefore decreased profits and depleted capital in a dramatic way. Hurricane Hugo in 1989 and Hurricane Andrew in 1992, the San Francisco earthquake in 1989, and the Northridge earthquake in 1994, and wildfires in Santa Barbara County, California in 1990, Oakland, California in 1991, and Orange County in Los Angeles in 1993 imposed losses for which companies had inadequate reserves. Each of these catastrophes was devastating, and each had its effect on insurance companies and the insurance market. Hurricane Andrew was, until Hurricane Katrina in 2005, the costliest natural disaster on record in the United States. Andrew swept ashore near Homestead, Florida, with sustained winds of about 150 miles per hour. The peak winds could not be measured because they destroyed the measuring devices. The hurricane was blamed for 40 deaths. It destroyed over 120,000 homes, and its economic cost totaled $30 billion. The effects on the insurance industry were devastating. About $16 billion of the total loss was covered by insurance. More than 600,000 claims were filed, and a reported 1/4 of the nation's insurance adjusters converged on the hurricane zone to handle the claims. All states suffered a $2.7 billion loss, and State Farm $2.1 billion. The volume of claims exceeded the funds the companies had set aside as reserves to cover losses. 11 companies were bankrupted, and 30 others lost 20% or more of their surplus. 10. The Northridge earthquake 2 years later also imposed huge burdens on the industry. The quake struck on January 17, 1994, with a magnitude of 6.7 on the Richter scale. Over 300,000 buildings were destroyed or damaged, and there was massive damage to autos and infrastructure. A total of 600,000 claims were filed, and the total covered loss exceeded $15 billion. The losses far exceeded the amount of premiums collected for earthquake coverage. State Farm, for example, paid $3.5 billion on 117,000 claims, having collected $1.2 billion in premiums. Farmers paid $2 billion on 36,000 claims, 4 times the amount it had collected in premiums. The soft market of the late 1980s and early 1990s, and the shocks to profits and capital by the string of natural disasters during the same period, spurred new corporate strategies. The response of farmers was the most obvious. AM Best, the authoritative rating agency for insurance company financial stability, lowered farmers' quality rating, and because farmers' losses cut into its capital surplus and therefore its ability to reserve for potential losses, it needed to raise an additional $1.6 billion or cease writing new policies. Part of the loss was made up for by the sale of $375 million in preferred stock the year after Northridge, but the principal means of recovery was a program the company called Bring Back a Billion. Leo E. Denley Jr., Farmer CEO, told employees, "We must each do our part to help restore surplus and ultimately improve our AM Best rating." 11. The mandate applied to all employees, including claim employees, who were asked to sign individual forms committing themselves to the goal. For claim employees, the way to bring back a billion was to reduce costs, of which the largest portion was claims costs. Each line of insurance was given its own goal for reducing its combined ratio. 12. Allstate pursued a different path. Following the hard market of the mid-1980s, Allstate embarked on an extreme soft market strategy of reducing underwriting standards and expanding its base of agents to increase its market share. The results showed dramatically in Allstate's book of business. Between 1985 and 1990, the company's share of private auto insurance sold grew from 10.4% to 12.4%, and its share of the homeowners market grew from 9.6% to 12.4%. All of this came at a cost to the bottom line and therefore to reserves, however. Its pre-tax operating income fell from $415 million in 1988, when the last of the hard market profits were flowing, to $41 million the next year, and it suffered a loss of $380 million in 1990. The natural disasters imposed more losses. Overall losses were almost $2 billion in 1992, the year of Hurricane Andrew, and $330 million in 1994, due in part to the Northridge earthquake. Even more important was the decision to separate Allstate from its lifelong connection to Sears. Allstate began in effect as an adjunct of the Sears catalog. In 1930, insurance broker Carl Odell, while playing bridge with his neighbor Robert E. Wood, CEO of Sears, suggested that a low-cost way of selling insurance would be through direct mail and the Sears catalog. By the early 1990s, however, Sears decided to focus on its core retailing business and divest itself of its three financial services subsidiaries: Coldwell Banker Real Estate, the Dean Witter Discover Brokerage and Credit Cards, and Allstate. In 1993, Sears engaged in an IPO to sell 20% of Allstate, and in 1995, it distributed the remaining 80% to Sears shareholders. In part due to the influx of new capital, Allstate embarked on a period of increased profitability. Its operating income grew steadily for 5 years after 1994, the year of the Northridge earthquake, and it saw its profits range from $1.1 billion to $4.8 billion over the next decade, during hard and soft markets. Lawyer and Allstate critic David Berardinelli notes another coincidence of events. After Allstate achieved its independence from Sears, the rewards to its executives under incentive compensation schemes would depend on its own profitability. It was just at this point that Allstate brought in management consultant McKinsey & Company to re-engineer its claim practices to make them more profitable. Allstate was not unique in its new emphasis on stock price and shareholder value. Looking back in 2001, Richard Stewart, former superintendent of insurance for New York and president of the National Association of Insurance Commissioners, described the shift in the industry as from orientation toward policyholders to orientation toward stockholders. Securities analysts and corporate managements emphasized shareholder value, and by stock options, the alignment of management's interests with those of stockholders. The effect on claim practices was direct. Through dividends and appreciation, stockholders get the benefit of what is not paid out for claims. 13 Paul Haas, CEO of reinsurer Center Cat Limited, commented, "In an industry that in the past has been dominated by dinosaurs, we are beginning to see some mammals evolving." Mammals, according to a 1996 report on the industry in Best's Review, were marked by financially oriented owners who will pay more attention to the bottom line. The report described character as the new key to success, but defined character in a particular business school mentality way: the ability to make the tough decisions necessary to improve profitability, where cost cutting is the main driving force in the property casualty industry today. 14. And as elsewhere in American business in the 1980s and 1990s, profitability in the long term is too long to wait, and financial results need to be measured here and now. Multinational insurer Allianz has taken the logical step of feeding the demand for up-to-the-minute reports by providing news on financial information and share prices by text messages sent to investors and analysts' cell phones. One indication of the shift in emphasis was the move through the 1980s and 1990s by dozens of insurance companies to demutualize, or to shift from being mutual companies to stock companies. Mutual companies are owned by their policyholders, so policyholders share in the company's profits through the payment of dividends on their policies, effectively a reduction in the premium rate. Stock companies are like any other corporations, owned by their shareholders, to whom management is responsible and who reap the financial rewards if the company is profitable. The attraction of demutualization was the access to capital markets. Mutual companies can only build the capital needed to sell policies through retaining profits and surplus, but stock companies can attract outside investment. When companies were capital constrained in the 1980s and 1990s, conversion enabled them to build surplus quickly through the sale of stock. The presence of ownership shares also provides an easy means of compensating key executives by awarding stock or options through executive compensation programs, and it provides currency for the company to grow through corporate acquisitions. Once a company demutualizes, though, it is subject to the discipline of the stock market. Mutual companies, at least in theory, serve only the interests of their policyholders, the owners of the company. The measure of value in a stock company is the price of the stock, and the company's principal obligation is not to its policyholders, but to its shareholders. Even those companies that remained mutuals increasingly focused on growth and revenue. Warren Buffett complained that State Farm, the largest property casualty insurer and a mutual, was taking huge underwriting losses at the end of the long soft market of the 1990s to maintain its market share, about 18% compared to GEICO's 6%. Liberty Mutual has grown to become the sixth largest property casualty insurer by acquiring other companies, including Ohio Casualty and Safeco. Although as a mutual it has no investors, it does have an investor relations department. State Farm's strategy exemplified the vicious war for market share, fought mainly through price cutting, that broke out in the 1990s in auto insurance, the largest segment of property casualty insurance, and that exacerbated the financial pressure on companies. 15. The stage for price competition was set by a new flexibility in the setting of rates for premiums. From the rise of insurance in the 19th century through the U.S. Supreme Court's decision in the Southeastern Underwriters Association case in 1944, insurance companies had formed cartels to fix premium prices, sometimes under the nominal supervision of state regulators, and the regulation of premiums was neither vigorous nor effectual, as a leading insurance treatise gently described the situation. 16. When the court held that insurance could be regulated by the federal government as a part of interstate commerce, the insurance industry and state regulators lobbied Congress to enact the McCarran-Ferguson Act, which allowed states to preempt federal regulation of insurance, making the insurance industry and Major League Baseball the only two industries exempt from the reach of the federal antitrust laws. Within a half dozen years, nearly every state had done so in the area of rate regulation, typically by legislation that established rating bureaus. The bureaus allowed companies to collaborate in sharing information about risks and losses and in setting premiums, and therefore avoid price competition. 17. Beginning in the late 1960s, pressure from the industry for more independence in rate setting and dissatisfaction from consumers over high auto insurance rates led to an opening up of the process of regulation. While some states continued to require approval of premiums and even imposed special restrictions on rates for auto insurance, many others opted for open competition, in which companies could adopt new rates without prior approval from state regulators. In general, there was more flexibility in setting rates and an attitude that price competition was valuable. Price competition then put increased pressure on claims, as cutting prices meant cutting costs, and the principal component of a company's costs is its loss expense. The new flexibility in setting rates showed the increasing emphasis on price as a means of gaining new customers. The results of a survey announced at the 1996 annual meeting of the National Association of Independent Insurers showed that the key driver of sales was low cost, with satisfactory claims service far behind. 18 top industry executives in the room, including CEOs Jerry Choate of Allstate and Thomas Crawford of Prudential Property and Casualty, professed to be surprised and troubled by the results, much perhaps as Captain Renault professed to be shocked to find gambling at Rick's Cafe in Casablanca. New marketing strategies became the essential weapons in the war over price and customers. Insurance became more like a commodity, a standard item sold off the shelf for which price becomes a principal feature. Progressive's television commercials gave life to the concept by portraying an insurance supermarket in which the perky sales clerk, Flo, helped consumers take policy packages off the shelf and to the cashier. It is a commodity of an odd sort, certainly, since policies vary greatly. Nevertheless, for many customers, most of the policy terms are invisible, and the only things that matter are the amount of coverage and the cost of the premium. Traditionally, insurance was sold through agents. either independent agents who worked for themselves and sold the policies of several companies, or captive agents who sold the policies of only one company. A key to the success of State Farm has been its army of local agents, a tradition begun by company founder G.J. McCurl in 1922. Dealing with an agent is attractive to buyers who have more complex needs, want personalized service, or are brand loyalists who prefer to have an ongoing relationship with a company and its agents. But treating insurance as a commodity, particularly a commodity sold through call centers and websites, made growth possible without such an army. If an insurance policy is a standard product, or if its options are standard, many prospective buyers will see little value in dealing with a middleman agent. Instead, purchasers can go directly to the company, and the company can both reach out to new markets and lower its cost of distribution at the same time. 19. Thus, the modern industry maxim, personal lines like homeowners and auto insurance compete on price, and commercial lines, which are more complex, compete on service. Allstate's use of mail order and the Sears catalog was an early example of direct marketing, but the company that made the best use of the technique and the one that would transform the entire industry in the 1990s and after was GEICO. Originally, the government employees insurance company, GEICO's strategy was to reduce costs and therefore premiums by marketing through the mail rather than through a sales force of agents. The problem in this strategy was that agents didn't just sell policies. They also evaluated and screened clients to make sure the risks were appropriate to the premiums. If direct marketing produced undesirable customers, the whole system would fall apart. GEICO's substitute for agents performing these functions was, as its original name suggests, to limit its clientele to government employees who were presumed to be more responsible. Beginning in the time of World War II and its aftermath, when GEICO expanded greatly, government employees also were an appealing market because there were so many of them. The system was so attractive that in the fall of 1950, a young Warren Buffett sold 3/4 of his investments to buy 350 shares of GEICO stock. Decades later, he would acquire the entire company for Berkshire Hathaway, where the premiums it collected would be a major source of capital for Buffett's other acquisitions. 20. Price competition and direct marketing caused upheavals in the industry. From 1995 to 1999, for example, the share of the private passenger auto insurance market held by the industry's perennially largest company, State Farm, fell from 21.6% to 18.9%, while direct marketers increased their share. GEICO from 2.5% to 4.1%, and Progressive from 2.6% to 4.8%. State Farm responded when its chairman, Ed Rust Jr., announced the big dog is off the porch. 21. It cut its rates and underwriting standards to regain market share, reducing auto premiums by $2.7 billion and paying out an additional $2.6 billion in dividends to policyholders, further reducing their premium costs, producing a loss ratio 14% higher than GEICO's, all at the expense of profitability. In the short term, this competition squeezed profits for all. In the long term, it was unsustainable and increased the pressure to cut costs, an effect that made low-cost companies the most likely to be successful and therefore put pressure on claim practices. 22. The industry recognized the changes. As Ted Kelly, CEO of Liberty Mutual, acknowledged, personal lines is now a merchandising business, and GEICO is doing it remarkably well. 23. In 1999, Allstate shifted its marketing strategy, aiming to reduce annual expenses by $600 million by cutting 12% of its workforce, expanding into call centers and internet sales, and moving away from its historic reliance on company agents. In 2007, 1 out of 20 insurance company websites offered online purchasing. A year later, 1 out of 4 did so, and nearly all at least offered online quotes. Even regulators got into the business of online quotes. In 2008, the Massachusetts Insurance Department, treating insurance as a commodity, established its own website that enabled consumers to shop for prices for car insurance by providing their zip code, the number of years they have been licensed, the type of vehicle, their driving record, and the coverage wanted. 24. The shift to direct marketing and the growth of price competition to attract new customers spurred what former Allstate CEO Edward Liddy, later picked by the federal government to run AIG after the government's bailout of the insurance giant, called an advertising arms race. Insurance companies have always advertised, and through their advertising, the companies have positioned themselves as much as their product. Much of the early and iconic insurance advertising focused on the security provided by the company, particularly with respect to the security of claim payments. In an ad in Harper's Weekly magazine on April 24, 1869, the Travelers Insurance Co. of Hartford touted its claims record. More than 10,000 claims of policyholders for death or injury by accident have been paid, showing the value of accident insurance, including, oddly, the payment to Mr. Chas M. Rogers, whose mysterious murder created such a sensation. Price was not irrelevant, however. The ad also promised a policy costs but little, try it. 25. Two of the most famous slogans in American advertising history emphasize insurance companies' promises to provide security. Allstate's "You're in good hands with Allstate," with the image of cradling hands, created by Davis W. Ellis, Allstate's general sales manager in 1950, and State Farm's "Like a Good Neighbor, State Farm is There," with the clever jingle written in 1971 by a then little-known songwriter named Barry Manilow. More recently, Allstate hired actor Dennis Haysbert, a warm, trustworthy presence from his portrayal of President David Palmer on the Fox television series 24, to deliver the message that security and confidence are Allstate's stand. Liberty Mutual's remarkably popular responsibility campaign is to the same effect, with a series of commercials on a pay-it-forward theme, with ordinary folks demonstrating random acts of kindness and caring echoed in the line. When an insurance company does it, it's called Liberty Mutual. Even Geico occasionally joins the trend, with real customers' stories about Geico's claim service jocularly retold by celebrities from James Lipton and Phyllis Diller to Mrs. Butterworth. Pioneered by Geico, insurance companies increasingly position themselves as funky as well as secure. Through its geckos, cavemen, and mix of celebrities and real people, Geico has increased its ad awareness to more than 9 out of 10 shoppers, significantly more than State Farm or Allstate, increased new customer acquisition at a rate almost half again as high as other companies, and increased market share in private passenger auto insurance from 5.1% to 7.2% from 2003 to 2007, moving into third place overall. Geico's style also set a tone for attracting attention, a style that has been copied by such oddities as Esserance's animated commercials and Nationwide's Life Comes at You Fast campaign, with such 15 Minutes of Fame wonders as Fabio, Kevin Federline, and American Idol antihero Sanjay Malakar. Even staid State Farm has responded by hiring basketball superstar LeBron James to attract younger shoppers. But the dominant focus of insurance advertising in recent years has been price. Geico's 15 minutes could save you 15% or more on car insurance has become the new standard. Progressive advertises its comparison shopping approach and frequent discounts. Esserance's pink-haired cartoon heroine, Erin, is the only one who can stop overpriced car insurance from taking over the world. Allstate touts that it will lower rates for avoiding accidents and will not raise rates after an accident. Only Chubb broke the industry norm and emphasized its strong record of paying claims and denigrated other companies' claims practices. It warned in one advertisement that not all insurance companies treat you the same. If being treated fairly and paid quickly are important to you when you or your business has a loss, you want Chubb. And in another quoted a Worth magazine article that reported, Chubb's best feature is a 3-decade history of paying claims that other companies might balk at. Low prices don't come cheap, though, because only expensive advertising can sell the message of low price, particularly for direct marketers such as Geico and Progressive. Television advertising is particularly expensive, but particularly necessary. As Steve Sullivan, Senior Vice President for Communications at Liberty Mutual, noted, aside from the ubiquity of television in American life, our business, insurance, doesn't have a tangible product. So what television does for us is allow us to establish an emotional connection with a consumer, sight, sound, emotion, and nothing else does that, yet. 26 expenditures on advertising by the 50 largest insurers doubled in the 5 years between 2001 and 2006, from $1.28 billion to $2.48 billion, making insurance companies among the top spenders on advertising. On Advertising Age's 2008 list of mega brands, the biggest spenders of advertising dollars, Geico stood at number 13 with $619 million. State Farm was number 17 with $436 million, and Allstate number 30 with $362 million. The biggest spenders are communications companies, with Verizon at number 1 and AT&T at number 2, with expenditures of $2 billion and $2.0 billion respectively. 4. McKinsey redefines the game, claims as a profit center. The extended soft underwriting market that began in 1988, the shocks of natural disasters in the late 1980s and early 1990s, the increase in medical costs and other claim sources, the growing importance of price competition, and the new mania for profits and growth set the table for the transformation of claim practices and the rise of delay, deny, defend. It was left to McKinsey & Company, the mega consulting firm that redesigned much of the corporate world to serve the meal. The main course: to violate the fundamental principle of claim handling by redefining the claim process as a profit center. One of McKinsey's maxims is that the firm never sells. That is, it does not do what its business clients do, namely, advertise and promote their services to potential customers. The firm does, however, aggressively market itself by publishing a semi-scholarly journal, the McKinsey Quarterly, supporting an economics research center, the McKinsey Global Institute, publishing reports, and encouraging publicity through the press and word of mouth in the corporate community. With a remarkable lack of embarrassment, one of the firm's white papers on the insurance industry, Factory and Firm, The Future of Claims Handling, provides the best retrospective of the transformation of the claim process that increased delay, defend, and defend of McKinsey's own role in the change. The story begins with the traditional claim process, in which claims adjusters had substantial autonomy in doing their work and authority in settling claims. In the 70s, McKinsey states, claims was seen largely as an art, with senior claims managers as craftsmen deserving of great freedom and latitude. Some believed that this posed little risk, because the result was really determined by the underwriting decisions made months or years earlier. Claims managers deserved great freedom and latitude because the objective of the process was to arrive at a fair value for the claim, consistent with the underwriting decisions, the promise of indemnity the company made to the insured to pay the insured's full loss within the limits of coverage. The company would be profitable or not because of the decisions made by underwriters and actuaries. The adjuster's job was to pay what was owed. But the financial situation presented a challenge to this model. By the 80s, with costs growing rapidly, claims status as an art came increasingly under fire. Management began looking to claims for more cost efficiency, and while the indemnity result was still largely seen as set by underwriting choices, the focus shifted toward managing the loss adjustment expense more aggressively. Good management takes hold as loss adjustment expense, the cost of processing claims, is cut, but not in a way that violates the nature of the insurance relationship and the promise the company makes to its policyholders to pay for losses suffered. Then came the key moment in the rise of delay, deny, defend. By the 90s, the pendulum began to swing back the other way. After years of squeezing the cost side, management recognized huge opportunities to rebalance and invested cautiously in LAE, loss adjustment expense, to capture indemnity savings. The concept of leakage, or total economic opportunity, came into vogue as firms, led by McKinsey, encouraged many in the industry to use closed file reviews, CFRs, to measure the trade-offs between LAE investments and indemnity accuracy. These projects frequently identified huge indemnity opportunities and, in some cases, under-resourced claims organizations. Many executives used CFR data to make new investments in claims and reaped substantial economic improvement as a result. In the 1980s, the emphasis was on cutting the cost of administering the claims department, monitoring adjusters' salaries, introducing technological efficiencies, and using fewer paper clips. The real money in claims, though, is in the amount paid out in claims and not in the expenses. In 1992, for example, for every premium dollar taken in property casualty companies paid 13 cents for the expense of running the claims department, but paid out 72 cents in claims. So in the 1990s, the focus shifted to leakage. McKinsey's factory and firm describes leakage as the fall off from indemnity accuracy, or how much more the company paid on claims than it should accurately pay. But the goal was smaller payouts, not accurate payouts. Huge indemnity opportunities and substantial economic improvement result only from paying less in claims, not more. New investments in claims processes could capture indemnity savings by spending a little more or a little more intelligently on the claims process, particularly by introducing computer systems to measure the value of claims and spending money on lawyers to fight them. Companies could cut the amount paid to their insureds and their victims dramatically. Substantial economic improvement resulted as the claim process became a profit center for the company. The focus of the claim process was no longer on paying a fair amount promptly, but on paying or not paying in amounts at times and under conditions that increase the company's profits. McKinsey brings the story up to date. By the end of the 90s, the leakage story had grown more complicated. While focusing largely on indemnity, some carriers have seen expenses on the LAE side creep up. Additionally, leakage measurement itself can be costly and difficult to sustain. Some carriers have been searching for ways to measure leakage in a more cost-effective, rapid manner while sustaining objectivity. Others have wanted to add measures that focus more on the customer service components of claims handling. Finally, some managers believe that while leakage measures are very useful for guiding an organization, they want additional operational metrics that are tied to near-term outcomes. In short, claims payouts need to be kept down, but claims costs are part of the story too. Both leakage and costs are important, as are additional operational metrics, such as how many claims are disposed of how quickly. McKinsey has been more than the chronicler of changes in claims practices. It was the architect of those changes to such an extent that the credit that it led the movement to bring leakage into vogue is a modest one. The firm was founded in 1926 by James O. McKinsey, formerly a professor of accounting at the University of Chicago. 1. The principal builder of the modern firm was Marvin Bower, who joined the firm in 1933. Bower, holder of a law degree and MBA from Harvard, spent 3 years at the prestigious Cleveland law firm of Jones, Day, Revis, and Pogue before joining McKinsey. His aim was to build a new type of management consulting firm on the model of the leading professional firms in law and accounting, which were characterized by high professional standards, ownership by active partners, and a lifelong career commitment. For decades, McKinsey was the gold standard in management consulting, with its advice sought by the world's largest corporations, its reputation burnished not only by the firm's A-list clients, but also by the pronouncements of its executives and alumni, such as In Search of Excellence, the best-selling business book by former McKinseyites Thomas Peters and Robert Waterman. McKinsey claims to have served 147 of the world's 200 largest corporations, and its services come dear. Annual fees routinely cost $10 million, with its largest clients paying $50 million a year and more. 2. Employment at McKinsey was prized by graduates of elite MBA programs. For a dozen years, they scored it as the most popular place to work in Universum's Ideal Employer Survey, until it was supplanted by Google in 2007. 3. McKinsey's most famous engagement became more notorious than notable. Enron was headed by former McKinsey partner Jeffrey Skilling, who brought his reputation for analytical brilliance, McKinsey methods, and many McKinsey consultants to that ill-fated company. McKinsey consultants were part of Enron's transformation from a natural gas pipeline company to a pipeline for impenetrable financial transactions. Prior to the firm's collapse, the McKinsey Quarterly touted Enron's new Petropreneurs, who were able to build a better mousetrap and issue a wake-up call to the oil industry through intermediation and risk management skills and deployment of off-balance sheet funds. 4. McKinsey deployed teams of intense MBAs on its engagements. The prospect of this kind of searching analysis was not always welcome down the management line. As Fortune magazine described the prospect of a McKinsey engagement, It begins as a rumor of impending destruction, the way a Category 5 hurricane first appears on a radar screen as a smudge off the west coast of Africa. I was in a meeting with Chuck, somebody will say, eyes lowered to hide his expression, and he said something about McKinsey. 5. What McKinsey offered, however, was an analytical method that presumably enabled it to analyze and improve a company's businesses better than the people running the business on a day to day basis could. 6. By the turn of the 21st century, however, the allure of involving management consultants in every aspect of a corporation's business had faded because of both the considerable expense and the questionable results. The notion returned that people actually involved in a business knew more about it than a bunch of beefed up MBAs with big egos who charge a lot to tell executives what they should already know, as one CEO put it. 7. As time went on, the perception of limited value and great cost caught up with the consulting trade, and many clients cut back on engagements, and consultants in turn cut back on expenses and employees. 8. The McKinsey approach that was brought to insurance claims begins by accumulating as many facts as possible about a company and its context from as many sources as possible, thereby allowing its consultants, who are outsiders to an industry, to compensate for their lack of experience. Then the consultants describe all of the issues potentially involved in the business and define the problem to be solved. Once the facts have been identified and the issues defined, the consultants generate an initial hypothesis. Oddly enough, McKinsey consultants, perhaps new to the industry and having done only a preliminary review of background facts and a definition of issues, propose the answer to the company's problem before they do most of the work on the engagement. The point is, as former McKinsey partner Ethan Raziel explained it, figure out the solution to the problem before you start. 9. The initial hypothesis needs to be tested, possibly reformulated, perhaps even rejected, but it becomes the roadmap to solving the client's problem. Every consulting problem is different, but no problem is entirely unique. McKinsey has a wealth of knowledge to draw on from prior engagements. It also employs a toolkit of techniques that were used with particular effect in its work for Allstate, State Farm, Farmers, Liberty Mutual, and other insurance companies. One is to identify the key drivers, or the most important factors affecting the client's problem. C. Another is the focus on core process redesign, also called business process redesign, or re-engineering, which would, in its Allstate iteration, become Claims Core Process Redesign, or CCPR. Core process redesign conceives of a business as composed of a small number of core processes, new product development or order generation and fulfillment, for example, rather than traditional functional units, research and development, manufacturing, and marketing, and then rethinks those processes to maximize the company's objectives. 10. The final part of every consulting engagement is implementation, and McKinsey is rigorous about implementation of its ideas. Consultants sometimes are criticized for generating big ideas that cannot be put into practice. McKinsey typically insists that part of its obligation is to create a detailed plan for implementing its ideas, from buy-in and direction at top levels of management to the lowest possible level of detail. Not just what should happen, but what will happen, how, and by whom. Projects differ in scope, of course, but a major redesign, such as McKinsey brought to Allstate and other insurance companies, is a multi-year project, the effects of which last for decades. A moderate redesign is the goal. As a McKinsey article of that name argued, any redesign effort large enough to produce a significant bottom-line impact has to stir up and sustain a critical mass of change in an organization's culture. True redesign efforts are never really completed. 11. In the 1980s, McKinsey likely had consulted with a number of insurance companies, including State Farm, Hartford, and USA, the United Services Automobile Association. Consistent with the timeline in its Factory and Firm white paper, these engagements probably focused on achieving efficiencies in the cost of processing claims. 12. With that experience and a few months of fact gathering, McKinsey consultants applied their systems to redesigning Allstate's claim processes. They identified the core issues in descending levels of generality. The overall core process redesign objectives were: 1. Build customer-focused organization with service levels equal to or better than that of our competition. 2. Redesign activities and core processes to significantly improve Allstate's competitive economics over the intermediate and longer time period. 3. Develop a home office and field organization structure that yields competitive advantage, becoming a low-cost, broadly based insurer for the selected level of service by customer segment. At this level of generality, the objectives seem unobjectionable and even laudable. A major company should strive to provide service equal to or better than that of our competition. At least one court that looked at some of the McKinsey documents, and Allstate manuals that drew on them concluded that, unless read in a way to give meanings to words that are rather far-fetched and improbable, they lacked a sinister nature. 13. As McKinsey developed its hypothesis in more detail and implemented the redesign, its effects became more apparent. The elements of the hypothesis for redesign were based on the drivers of value in the claim process, a hypothesis that was mapped out in detail early in McKinsey's engagement and would be borne out throughout the implementation of CCPR. McKinsey stated the basic principle: our change goal is to redefine the game, to question, improve, and radically alter our whole approach to the business of claims. The game would be radically altered by making the claim process a key to increasing Allstate's profits, and at every step the focus would be on reducing the amounts paid to policyholders and accident victims. Every element of the claim process would be transformed. The accepted understanding had been that severities, the average paid on claims, were the cost of doing business. The new approach: we can and should manage specific components of severity to provide greater financial support to the company. Manage how? Among other ways, focus on paying less on the largest group of claims, because our volume of small to mid-sized claims actually offers the opportunity for greatest improvement. Discourage claimants from being helped by lawyers and pay them less when they don't have lawyers to help, because the way we approach claimants and develop relationships will significantly alter representation rates and contribute to lower severities. In short, as summarized at a claim management conference in the spring of 1994, we will win the economics game. Winning will be a zero-sum game. We will win the game in 2 phases. Phase 1, consistent execution of better plays and new game plans. Phase 2, change rules and play a new game. Allstate's chairman Jerry Choate explained the new economics of claims to employees in 1997. In the long run, if we don't win on the claim side of this business, we don't win, because that's where all the leverage is. 3/4 of every dollar that leaves this company goes to pay claims. So we have to build a long-term, sustainable, competitive advantage in claims. It's as simple as that. 14 decades later, the company could report that the goals of winning on the claim side remained the same and were being met. The most important factors we monitor to evaluate the financial condition and performance of our company include severity, average cost per claim, and loss ratio. Our property liability combined ratio, the ratio of claims payments and expenses to premiums, has been below 90% over the last 2 years, an underlying indication of our ability and commitment to shareholder value. 15 CPR was an ongoing process designed to be built into Allstate's DNA and to continue to evolve over time, because true redesign efforts are never really completed. 16. Although Allstate claims not to have kept all the McKinsey innovations, at least through 2007, Christine Sullivan, Assistant Vice President for Claims in Allstate's home office, reported that Allstate still uses most of the claim handling processes and procedures developed and implemented as part of CCPR for investigating, evaluating, handling, and resolving automobile bodily injury claims, except that some of the processes and procedures have been modified since initial implementation. 17. Allstate's most recent automated claims system, NextGen, a technology and service platform that supports our reinvention of the consumer experience, has been described by industry analyst Paul Newsome as round 2, if not 3, 4, or 5 of CCPR. 8. McKinsey & Company installed similar plans at other companies. At State Farm, Claims Vice President G. Robert McCurl conveyed the goal to the company's divisional claims superintendents in 1986, especially in relation to the bottom line that I want to talk about, and that is being better than the competition in everyday claim handling. Better how? Really, what I'm talking about is the loss ratio, because that's the difference between profit and loss. And if our competition settles claims for less money than we do, we stand a good chance of being non competitive. Now, you all know losses are a function of frequency and severity. You can't do a whole lot about the frequency, but severity is strictly in our ballpark. 19 State Farm's initial program for revamping the claims process was known as ACE, for Advancing Claims Excellence. 20, but ACE was only one of several programs in operation at one time and over time. The different versions included Fire ACE for homeowners insurance, Auto ACE for auto bodily injury claims, and Estimatics ACE for auto property damage. Siblings included Total Evaluation and Claims Handling, TEACH, and others lacking in catchy acronyms such as Medical Management, Service First, also for auto damage claims, Auto Claims Reorganization, Redesigning the Organization, Quality Reviews to track progress in achieving claims goals, and Business Process Improvement, the way we handle claims from beginning to end, the various people who handle them, and the system that we have in place. The point of ACE was the same as Allstate's CCPR. The ACE basic definitions included shortfall. Quality shortfall is the quantifiable difference between what was paid and what should have been paid to conclude a file. There was no comparable definition of longfall for cases in which too little was paid on a claim. As a program update reported by 2000, considerable opportunity exists in the area of loss payout. If ACE determines that there is a 12% claims payment shortfall nationwide, and we are able to reduce the shortfall to 10%, we have recovered the $2 billion savings in expenses. Frank Camella, a senior consultant in general auto claims and head of ACE, explained how ACE would implement its objectives. When we get to the settlement of losses, questions arise, particularly about overpayment. For example, you can have good trendings in average paid cost, but a close review of the files indicates we may be paying too much. Remember, our objective is to pay the appropriate amount. State Farm's objective is to pay the appropriate amount on claims, but questions arise about overpayment, not underpayment, when a review of files indicates the company is paying too much, never too little. Camella's prediction was borne out in looking at the data. A closed file review in one region reported the percentage of leakage, payment of claims for more than they could have been paid, and opportunities, the amount by which State Farm profits could be enhanced by cutting payments. In bodily injury claims, 12, 5% leakage costing $30 million, 10, 7% in personal injury protection, no fault, costing $15 million, and 5.8% in property damage costing $18 million. For State Farm, as for Allstate and other companies, particular programs and their monikers came and went, but the changes they instituted were evolving and permanent. Frank Camella stated, "Long term, after we get through this learning curve, the goal of the ACE group that I'm part of is to work ourselves out of a job. Ultimately, the success of this program is going to rest with the regionally assigned consultants. ACE is here to stay." 21. The company's bullet point introduction to ACE made clear that ACE is an ongoing process. ACE will become a way of doing business in the future, and ACE as a term will most likely disappear. 22, and disappear it did, but its effects stayed. In 2003, 5 years after the formal termination of ACE, State Farm Representative Steve Hassold testified that there were initiatives as a result of the ACE program that we are still using. The ACE program is gone, but things that it did are still in place. 23. Today, State Farm claims the ACE program was only used for a short period of time in the 1990s as a way to go after insurance fraud, and we have not used it since. 24. Farmers Insurance competed with State Farm for the best acronym with its ACME program, Achieving Claims Management Excellence. The epigraphs of its ACME Best Practices Manual were admirable. We provide the best value for the money in the industry. We will do everything in our power to restore people's lives to order. We do the right thing, whatever it takes. We pay what we owe, nothing more, nothing less. Then it got down to business. ACME provided a methodology for determining best practice within our organization while identifying potential opportunities for overpayments or leakage. Through these efforts, we will improve customer service, control loss costs, maximize productivity, and identify training requirements. Loss costs would be controlled by focusing on leakage. Overpayment or leakage is the indemnity and/or expense payment associated with incorrect or improper file management or untimely decisions. Overpayment leakage is that amount above an acceptable disposition or in excess of an acceptable range. Translated, we pay what we owe, but determining what we owe focuses only on identifying overpayments and leakage, not underpayments, and one supposes overflow. And the aim was to control loss costs, not increase them. For Farmers Acme, as for Allstate's CCPR and State Farm's ACE, the McKinsey principles applied. The claims process would be radically altered. Traditionally, companies pay what they should pay, with should defined by what the policyholder was owed. Transforming claims into a profit center would require focusing on leakage or on where they paid more than they should, where should was measured by the goal of reducing costs and increasing profits. The solution was to reduce payments to policyholders and other claimants. The solution would be implemented by redefining every step of the claim process and creating a new systematic claim process across auto and homeowners claims. 5. Mr. Incredible goes to work. The new systematic claims process, drivers, homeowners, victims of auto accidents, and other people who depend on insurance care about how well claims are handled, but not much about the internal workings of the claims departments. Claims are handled well when insurance companies pay what they owe, promptly and without muss or fuss. When claims departments become transformed into profit centers and the job of claims adjuster is redesigned to be a contributor to corporate profits, however, how claims departments work affects how well they work. With a new systematic approach to the claim process, claims departments work well for the companies, but sometimes not so well for those who rely on them. Once the key to the claim process was the frontline claims adjuster, who would investigate a claim, evaluate coverage under the policy, liability if it was in dispute, and damages. Negotiate with the policyholder or accident victim, and if the claim went to litigation, work with the lawyers. The adjuster was a claims man, literally likely to be an Army veteran with some college background who drifted into insurance instead of accounting, teaching, or sales. Being an insurance adjuster was an attractive job that allowed initiative. As Claims magazine gushed about the top portrayal of a claims adjuster in a film, Edward G. Robinson's Barton Keyes in Double Indemnity, one wonders how many young men returning home in 1944 and 45 chose their professions after hearing Keyes attempt to recruit Fred MacMurray's character, an insurance agent, to be his assistant with the speech. The job I'm talking about takes brains and integrity. It takes more guts than there is in 50 Salesmen. It's the hottest job in the business. To me, a claims man is a surgeon. That desk is an operating table, and those pencils are scalpels and bone chisels, and those papers are not just forms and statistics and claims for compensation. They're alive, they're packed with drama, with twisted hopes and crooked dreams. A claimsman is a doctor and a bloodhound and a cop and a judge and a jury and a father and a confessor all in one. Worn as late as the 1970s, most adjusters exercised a great deal of discretion. The adjuster saw his job as settling claims for a fair amount. The common understanding, as sociologist H. Lawrence Ross reported in his study of adjusters, was, we close the case out with everybody happy by paying what the claim is worth. Fairness was the goal even in liability claims when the claimant was not the policyholder. Ross quoted a typical sentiment, "We are not in business to chisel the public, I don't feel. If we know it is worth $20,000, then let's pay $20,000. To the claimsman whose job demands brains, integrity, and guts is now much less in evidence because most adjusters are more closely bound to office and computer and are subject to elaborate systems that direct their work. Today's adjuster is less often an advocate for fair treatment of the consumer because adjusters are often required to conform to the demands of the claim processing system and are evaluated on their conformity to the system, including explicitly or sub rosa on the amount paid out or not paid out in claims. The contemporary cinematic portrayal of the adjuster comes from the animated satire The Incredibles. Bob Parr, the day-caped superhero formerly known as Mr. Incredible, toils in the drudgery of an office subject to the berating of his penny-pinching supervisor, Gilbert Hoof. Parr doesn't understand the adjuster's new role. When he explains his conception of the job, we're supposed to help people, his boss Hoof corrects him. We're supposed to help our people, starting with our stockholders, Bob. Parr's escape from tedium, available only to movie superheroes, is to subvert the system by actually helping claimants, as Hoof complains, in exploiting every loophole, dodging every obstacle, penetrating the bureaucracy. Insurance adjusters are part of the armies of bureaucrats and office workers who staff modern corporations and government. Like soldiers in all armies, adjusters, or claim representatives, as the industry would have it, have different functions and ranks. Some highly skilled, highly paid adjusters investigate and resolve multi-million-dollar claims involving fires at commercial buildings. Others process routine claims coming from fender benders. The federal government's Bureau of Labor Statistics reports a total of 209,000 adjusters, claim examiners, and investigators of all types in private employment. Of these, 141,000 work directly for insurance companies, and most of the rest work for independent adjusting companies or for themselves, called on when insurers outsource claims processing or for large-scale catastrophes when their in-house resources are insufficient. Today, the key to the claim process is the system, not the adjuster. A highly organized, industrialized system for processing claims is the key to modern insurance adjusting. The model is the shift from individual craftsmen as jack of all trades to specialized production in which each worker in a factory produces a single product, over and over. As an article in Claims describes the scene, adjusters have less street experience than 30 years ago. Entire generations of claim staffs have spent their entire careers inside the office. Computer processes in which time study experts have removed precious keystrokes have also removed basic information gathering tools. Claims are grouped and handled by type, by subtype, and by dollar amount. Auto claims are separated from homeowners claims. Within auto claims, specialized units serve no-fault claims, property damage, minor personal injury, and major injuries. The Special Investigations Unit is separate still, to investigate possible fraud and to deal with a range of cases in which the company's liability can be contested. State Farm, for example, has units for homeowner fire large loss, homeowner complex casualty environmental, auto centralized total loss, auto complex property damage, auto no fault litigation, auto uninsured, underinsured motorist, and more. And the claims units are increasingly centralized as well as specialized. In 2001, for example, Allstate began consolidating its offices that handle auto claims, with the result that about 40% of them are processed through 3 Auto Express centers in Alabama, Indiana, and California. 4, because the adjuster has less discretion, she needs less training, and the training that is provided is focused on applying the system. According to a survey by Claims, more than a third of insurance companies provide new adjusters with 2 to 4 weeks of training, and 1 out of 8 companies provide less than a week of training or no training at all. 5. Advanced training is provided for adjusters who specialize in more complex problems or larger cases, but always there is a point of view. An all-state training seminar included basic information about fractures provided by an orthopedist and red flags to watch for in a soft tissue injury provided by a physical therapist. 6, the knowledge that is needed for processing claims is built into the system and therefore does not have to be held by the adjuster. Less of the adjuster's job is involved with developing facts relevant to a claim and more to receiving facts from others, the policyholder, medical providers, the policyholder's attorney, contractors, and body shops. Then the information is entered into the system with accuracy and speed of data input essential. 7 adjusters have become less independent and more efficient from the company's point of view, with efficiency defined in terms of following the dictates of the claim systems. 8, a group of Allstate employees who brought age discrimination claims against the company complained that CCPR, Allstate's McKinsey-led claims core process redesign, relegated them to nothing more than data input clerks. The employees reported that they could only determine liability in accident cases by adhering to a liability matrix. They could only set reserves for claims after consulting a computer program, and they were limited in their ability to negotiate settlements by computer software and the CCPR manual. 9. The diminution of the adjuster's role was exposed in a class action suit brought by adjusters for farmers insurance, in which they argued that farmers improperly failed to pay them overtime to which they were entitled under California law. 10. Part of the evidence was farmers' own characterization of their role in its regional claims manual, which required that questions of importance must be decided by the branch claims manager and at a higher level by the regional claims manager, and only routine and unimportant tasks could be delegated to adjusters. The court further described the adjusters' role as clerks who processed information but did not make significant decisions, likening them to production workers in a factory. On matters of relatively greater importance, they are engaged only in conveying information to their supervisors. Again, primarily a routine and unimportant role. This characterization of their role in the company places the plaintiffs in the sphere of rank and file production workers. The systems dictate process and results, and adjusters are evaluated on their adherence to the system. According to adjusters who testified in the farmers' overtime case, the company conducted quality assurance audits of adjusters' work to ensure that they complied with the procedures, what one described as a do or die situation, with no gray area in audits re complying with policies and procedures. Either you complied or you didn't. Deviation from stated objectives was cause for termination. Another adjuster, too much Barton Keyes and not enough Gilbert Hoof, was repeatedly and severely criticized for using discretion and judgment in evaluating and adjusting claims. 11. The adjuster's new role, therefore, is less to be an experienced professional making an individual evaluation of each claim and more a clerk executing the demands of the system. From the company's and the adjuster's perspective, this makes each claim much like every other claim, which generates efficient and predictable results. From the policyholder's or claimant's perspective, of course, that is not the point of the insurance policy. The point is prompt and fair processing of a unique loss. The systems control the adjusters, and the systems are driven by information technology. An industry has developed to provide computerized systems to process the massive information that adjusters deal with, estimate the cost of repairs to damaged property, check medical expenses, evaluate personal injury claims, store and report on a claimant's history, and do everything else a claims department needs to do. Insurance companies can choose among Claims Desktop, Claims Office Suite, Claim Search, Claim Director, Claims Outcome Advisor, Claim IQ, including Medical Injury IQ and Liability IQ, and eClaim Manager, among others. Or they can develop their own systems. At an estimated cost of $125 million, Allstate has developed NextGen, which earned it a place among the top 100 innovative users of technology in Information Week's awards for 2008. Allstate hired Mike Jakowski, formerly a consultant with McKinsey & Company competitor Accenture, as Allstate's Vice President of Claims Technology Services to lead the development of NextGen. 12 NextGen's technological efficiencies reduce claim adjustment expenses and apparently also reduce Allstate's payouts to its customers. People seem to be happier with less money right away than more money after a lot of hassle, according to insurance industry analyst Paul Newsome of AG Edwards, commenting on the implementation of NextGen. 13. Two of the most widely used information systems are Colossus, which is designed to put a dollar value on bodily injury claims from car accidents, and Xactimate, which estimates the cost of repairs to damaged homes and other property. The immodestly named Colossus takes information about a claimant's injury, symptoms, trauma, treatment, and impairment, churns the information through more than 10,000 decision rules, measures the results against financial parameters input by the insurance company, and places a monetary value on an injured person's claim. Its moniker may not be immodest after all, because adjusters are often bound by the program's output. Reportedly, they can offer no more in settlement than Colossus allows, and they are evaluated on their ability to impose the program's dictates on claimants. Xactimate's name expresses similar hubris. It is software for estimating the extent of a loss and the cost of repairs that presumes to be exact. A property loss adjuster takes his Xactimate loaded laptop and measures, records, and lists information about the damaged property, and the program produces a dollar amount that will be the basis of the insurance company's payment of a claim. Um, if Colossus was colossal and Xactimate exact, they would benefit insurance companies and claimants alike. Unfortunately, like Hey-El in 2001, A Space Odyssey, or other computers run amok in science fiction movies, they can aspire to perfection free of human intervention, but not attain it. Each permits considerable error by adjusters, and each is subject to manipulation by insurance companies. Like other elements of the systematic approach to claims processing, they may favor efficiency and profits at the expense of accuracy and fairness. There is more on Colossus in Chapter 7 and Xactimate in Chapter 8. Creating a new approach to claim processing and payment with new structures and computer systems is not enough unless it is implemented by frontline claim adjusters on a day-to-day basis. In addition to training adjusters to conform to the system and putting them in front of computers that control much of their work, two principles are fundamental to this transformed claims process. First, as McKinsey & Company stated succinctly at a 1994 claims management conference, we get what we measure. Second, people respond to incentives. The principles are so basic that McKinsey's first presentation to Allstate management on September 28, 1992, emphasized the importance of measuring performance according to the company's objectives. Measurement systems that track claim performance in economic terms are critical to successful implementation. For a long time, the primary measurements of adjuster performance were pendings, the number of claims an adjuster processed and the speed with which he did so, and expenses, the costs of processing claims. McKinsey recommended that it was more important to measure the parts of an adjuster's performance that contributed directly to increased profits. For auto personal injury claims, the principal measures were the proportion of claims closed without payment to the policyholder and the average cost of payments made, and that approach spread. The first nationwide study of claim vice presidents of insurance companies and adjusting firms, conducted in 2001 by trade groups and the Computer Sciences Corporation, CSC, found fewer than half of the companies still measured average time to close a claim, and the number one measure of costs was severity, the average paid per claim measured by 85% of the firms. 14, the point of measurement, of course, is not to measure, but to use the results to advance the company's objectives. Part of the redesign of the claims process was to use the new measurements to direct employees' behavior toward the corporate goal of increased profitability. As McKinsey stated, part of the new game plan was mandatory standards and performance expectations. Each of the companies that adopted the new game plan set new expectations for employees and often used those expectations as a basis for incentives, positive and negative, in promotion, pay, and other rewards. For actuaries, underwriters, managers, and other insurance company employees, measures that align the employees' incentives with company goals, including the goal of profitability, are perfectly appropriate. Not so for adjusters. The adjuster's job is to honor the company's promise to pay what is owed, no more but no less. Whether and how much an adjuster pays in a particular case or all cases should depend only on how much the company owes on the claims. If the adjuster's pay is tied to reducing severity or cases closed without payment, the company has given the adjuster an incentive to violate accepted practices and break the promise the company made to its policyholders. As a survey of insurance personnel by ethics expert Peter Kensicki concluded, if the standard being established improves service to a stakeholder, it is ethically based. If it creates benefit for the employer at the expense of the rightful amount due a claimant, it is not. 15, indeed, this standard is so fundamental that is the law. A California statute, for example, prohibits insurance companies from paying adjusters any part of their compensation based on the amount for which they settle claims. 16, nevertheless, as one of Kensicki's respondents stated, the practice of performance-based compensating is growing, and we are hearing everybody's doing it as a defense. 17, the redesign of measurement and incentives was central to McKinsey's claims core process redesign at Allstate. McKinsey emphasized the switch away from an old focus on how efficient adjusters were in moving claims along and how much it cost them to do so, toward one more aligned with the new objectives of CCPR. Current processes are incenting and reinforcing behavior that does not reward shareholders. Currently, we measure expenses and pending. The new measurement approach will be based on the processes and activities required to achieve the desired outcomes. Merely measuring was not enough. Goals had to be set and behavior had to be rewarded and punished. McKinsey set goals that it described as aggressive. One goal for minor impact auto claims with soft tissue injuries to be met in the first year of CCPR and maintained thereafter was that the average claim settlement is equal to the amount established through the evaluation process. In other words, once Colossus or another system determined what the company was willing to pay for a claim, the adjuster's job was to make sure that the claimant got that amount and no more. To maintain an average settlement equal to the evaluated amount, for every dollar that one policyholder received above that amount, adjusters had to extract a dollar from another policyholder's settlement. Adjusters at Allstate received an evaluation by their supervisors, a performance development summary, or PDS, twice a year, and the supervisor would review the results with the adjuster. At these meetings, supervisors always discussed goals that reflected the amounts of the claims paid, including the percent paid at the Colossus evaluated amount. Adjusters were issued company Big Blue, presumably Allstate Blue, Citibank credit cards to use for work-related expenses, such as travel to attend training sessions away from their offices. Because the cards were not for everyday expenses, prior authorization was needed to use them. But the prior authorization would sometimes be used to give employees a bonus for meeting performance goals, including reducing claims payouts. Bonuses were small but frequent, consistent with an employee relations approach that frequent reinforcement is more important than the scale of the reward, and just as important to avoid tax liability. The recognition program brochure advised that non-cash gifts or awards given on an occasional basis to employees which do not exceed $100 are not taxable. 18. One employee's voucher showed bonuses including $20 for a successful, that is, low, rate of claims in which the insured was represented by an attorney, $5 for promptly contacting insureds, and $50 in other bonuses, accompanied by chintzy desktop publishing certificates with sentiments such as, "Congratulations! For your achievement in 3-day contact of claimants, you may charge $5 on your Allstate credit card." State Farm took a different approach, generating measurements that affected claims payouts, but avoiding documents that would demonstrate how they were used to put pressure on individual adjusters. Its official policy, as stated at a 1995 conference, was numbers are not developed below division level, can't develop quality shortfall below 100 files, so can't really take it down to claim rep level. 19. But that policy may have been a reaction to 1991 litigation in Alaska that exposed the details of its pay-for-performance process. Managers were warned not to state specific numerical goals on performance review documents, and instead to discuss the numerical goals with adjusters during their quarterly and annual meetings. The unrecorded goals included some for severity, such as, according to former senior adjuster Grace Hess, the average amount paid on claims. 20. The leader of a training session for adjusters emphasized the point of the meetings. The goal is to make sure claim reps leave the sessions understanding there will be consequences for the appropriateness of their quality claims resolution. Consequences include positive and negative ones. They have never been evaluated in this manner before. 21. Farmers Insurance had one of the most elaborate programs, actually, a series of measurement and incentive programs implemented over time, and one that has been the best documented in subsequent litigation. In 1992, Farmers inaugurated its Partners in Progress program, through which employees were told, "You and your supervisor will set performance expectations tied to results that help meet the company's business needs." The Partners in Progress manual explained that the adjuster and supervisor would discuss the most important components of the adjuster's job and the weight to be accorded to each component, on a scale of crucial, important, expected, and risk opportunity. Then you can expect that your individual performance ratings will play a key role in determining your pay level each year. Individual performance review forms show how this worked in operation. One employee's critical objectives included maintain indemnity costs at inflationary levels. That is, don't pay out more in claims than you paid out last year, accounting for inflation. The measures were specific, showing that employees' figures for the year and the change from the previous year. Average costs available are BI, bodily injury auto claims, $6,875, 14%, collision $4,425 plus 109%, comprehensive $1,688 and 1.5%, PD $1,092 net 29% compared to last year's figures. A manager from Tucson was lauded for cutting payouts and reducing the number of claims in which claimants were represented by a lawyer. Comparing overall costs as of second quarter 1995 versus 1996, Tucson BCO has succeeded in decreasing our total indemnity costs by 28% in 1996. This is an excellent result. Attorney penetration for second quarter 1996 was 49.7%, a decrease. These represent excellent accomplishments in light of our low-impact program. Following the Northridge earthquake in 1994, Farmers Bring Back a Billion program, discussed in Chapter 3, added urgency to measurement and adjuster incentives. William R. Hurst, a farmer's adjuster, testified that adjusters were told to deny everything you can. Adjusters were routinely evaluated based on the average amount we paid out in claims. I was specifically told by my superior that even a low-level office adjuster, who was much, much less experienced than I, was doing a better job than I was, simply because his average amount paid per claim statistics were lower than mine. I pointed out that I had much more major claims assigned to me than did this office adjuster, but this seemed to make no difference to my supervisor. 22 in 1998, Farmers shifted again, naming its revised incentive program Quest for Gold. Initially, it created bonus pools of cash and extra vacation days for offices that furthered the company's goals. The goals included normal business measures such as growth in premiums, but there was only one goal to which adjusters could contribute. Personal lines combined ratio, goal 98.54%. The combined ratio compares the amount paid out in claims plus the company's expenses to the premiums it takes in, and adjusters could contribute in only two ways. They could cut costs, say, by using fewer paper clips and making fewer copies, or by cutting what they paid out to farmers' policyholders and other injured parties. In its next iteration, the focus on combined ratio became even more clear. In a memo to all company employees on April 11, 2001, Farmers' top executives announced a new plan under which half of the company's cash profit sharing will be tied to achievement of company-wide combined ratio results, and Farmers Group employees will have their award tied to achievement of local combined ratio goals. John Lynch, Executive Vice President of Market Management, drove the point home. The number one priority, the number one goal, the number one objective for the year 2001 was to fix our combined ratio. We recognized that it would take the hard work of absolutely every member of the farmers organization: claims, underwriting, policy processing, market management, agents, district managers, everybody that's in a leadership role in the farmers organization. And I think there's no better way to reward people than to align what's really important for them. What are the things they really need to get done? What are the goals? What are the actions? What are the accomplishments? And you tie that together with compensation, and all of a sudden, you've got very solid alignment between our business goals, our actions, our accomplishments, and our compensation. So for 2002, we will be tying this kind of perhaps oversimplistic but very focused approach to your compensation. The next year, Michael L. Kent, Vice President of Human Resources, again exhorted all the troops, and now that 2001 is over, let's strive to do even better in 2002. What's important now? It can be summed up in two words: combined ratio. Every farmer's employee has a stake in our results. Ask yourself, where will my contribution be? Farmers denied that these company goals, vigorously asserted over and over again by executives and addressed to all employees, would affect the performance reviews of individual employees. In a 2003 hearing, for example, Farmers' claim manager for the Plains States region, James Keefe, was examined by leading bad faith lawyer James Aberesk. Keefe testified that there were no financial goals for individual claim representatives, and in Nixonian echoes, it would be wrong to have financial goals or expected results. When shown performance review documents that listed such goals, Keefe tried to explain, well, they're expected results. They're not necessarily goals. They're targets, or they can be a number of things. Goals may or may not be one of them. The North Dakota Insurance Department examined farmers' practices and reached a different and more definitive conclusion than Keefe. In 2004, it began a 3-year investigation of farmers' incentive practices, and in June 2007, it issued the report of its market conduct examination. The department had examined personnel files from the Bismarck office, over 5,000 pages of documents produced in civil litigation against farmers, and other affidavits, documents, videos, and company emails and memos. It had reviewed the company's Bring Back a Billion and Quest for Gold programs, among others. The report reached several conclusions. As early as 1990 and before, the management of Farmers Insurance Exchange set various goals for claims handlers and other employees in an effort to increase company profits and thereby grow company surplus. Employees were informed that their individual performance ratings would play a key role in determining their pay level each year. Many of the performance goals for individual claims employees were appropriate. However, goals that were arbitrary and unfair to policyholders and claimants were also identified. The Bismarck Branch Claims Office's PP&R's performance planning and review forms included unfair and arbitrary goals. 1, to maintain an average cost claim, allowing for inflationary amounts at the previous year's level or below. 2, to settle bodily injury claims within a predetermined range and maintain average managed medical payment amounts. 4, to increase the number of fraud referrals. 6, to close a set percentage of claims without payment. 7, to estimate the condition of damaged vehicles at or below the national average to minimize indemnity payments. These goals were set without regard to the nature or merits of the individual claims that might be handled by the individual claims settlement personnel. Farmers did not agree with the department's conclusions and argued that the company's leadership had changed in 2002, resulting in an enhanced awareness among claims handling staff of the need to pay what is owed on a claim in a timely manner and a clear understanding of its incentive programs. Despite its disagreement, farmers paid a fine of $750,000 and promised to eliminate incentive plans that utilize goals relating to settling claims within certain ranges, and to emphasize the importance of evaluating each claim on its own merit and to neither underpay or overpay claims. The North Dakota regulator's findings were confirmed in litigation brought by farmers' adjusters seeking to be compensated for overtime. Federal Judge Robert E. Jones found in 2004 that farmers had a settlement philosophy of "we pay what we owe, nothing more, nothing less," and it conducted studies of closed claims to ensure that CR's claims representatives are following best practices. But he also found that farmers had zero tolerance for overpayment of claims, with apparently a greater tolerance for underpayment. The claims studies focused on lost economic opportunity to the company in failing to pay as little as possible on a claim. Farmers set goals for leakage or overpayment of 2% for auto property damage and liability, and slightly more than 2% for property claims. The goals were to overpay by no more than 2%, certainly not to overpay by no less than 2%. 23. When policyholders or victims cannot be persuaded or coerced to take what the insurance company offers, it gears up to defend itself in litigation. The litigation may arise early and regularly, as in the strategy of denying minor impact, soft tissue claims, and forcing claimants to sue, or it may come only at the end of a more protracted period of investigation and negotiation over the value of a claim. The defense may be conducted by staff lawyers or by outside law firms. But just as war is too important to be left to the generals, for a systematic claim process litigation is too important to be left to the lawyers. Like adjusters, they need to be managed in order to maximize the insurance company's profits. Just as the first step in redesigning the claim process focused on costs At an early stage, insurance companies recognized that they could increase profits by spending less on lawyers. In the late 1980s, McKinsey analyzed 2,000 claims at St. Paul Fire and Marine and concluded that litigation management, including auditing the bills submitted by outside lawyers, cut costs by 20% or $50 million. 24. The conclusion was apparent. Lawyers retained by insurance companies are just another part of the claim processing system, and they are, for the companies, just another outside vendor of services, like the companies that furnish janitorial services or office supplies. As such, they should be subject to cost control systems, mostly put into place as part of the redesign of claim processing. Cost control begins even before the lawyer is retained. Up until the 1990s, outside lawyers were most often hired by insurance companies' local claims offices, often based on personal relationships between adjusters and lawyers. Hourly rates were negotiated based on the local market for legal services and the level of experience and expertise of the lawyers. 25 today, that is seldom, if ever, the case. Allstate, again, was an innovator, although it took much criticism for one innovation in lawyer hiring. Beginning in 1999, it began to use an internet-based bidding system for many routine cases. Outside law firms filled out a pre-qualification questionnaire indicating what types of cases they can handle and at what price. Allstate described anonymous cases on a website, and law firms bid for the cases on a modified flat fee basis. 26 insurance companies also control legal costs by auditing law firm bills, often by using outside auditing agencies or, increasingly, auditing software. The auditing imperative was spurred in part by some high-profile cases, including one in 1996, in which a Miami Beach attorney was convicted of submitting $5 million in false bills to Lloyd's. The response was dramatic. As Atlanta lawyer Terrence Sullivan described the situation, these auditing companies come in with a stereotype: all lawyers cheat. Bills are audited to ensure that they conform to the rules established by the insurance company, and they are often reduced as excessive. Work must be done by the least expensive person qualified to do it, and multiple attorneys working on the same matter are closely scrutinized. Excessive photocopying is discouraged. Even meeting to discuss a case with colleagues may not be paid for. 27 traditionally defense lawyers would be paid on an hourly basis. Now it is much more common for small cases to be paid a flat fee, or a flat fee up to the point of trial. A typical flat fee is $20,500 to $3,000, much less than the lawyer would receive if paid on an hourly basis. Some companies, in effect, franchise their legal work, selecting one firm to do all cases of a certain kind in a city or area and paying a reduced hourly rate that includes all costs. 28. Because the processing of litigation has become routine, insurance companies now require firms to submit bills using complex software that then organizes, audits, and reports on the company's legal costs. The American Bar Association's litigation section and the American Corporate Counsel Association, with the participation of major law firms and corporate purchasers of law firm services, have aided the process by developing the Uniform Task-Based Management System, UTBMS, litigation task code set that contains a digital code listing all the elements of all the tasks and activities associated with litigation. The Defense Research Institute, DRI, adopted recommended case handling guidelines. Together, the two provide a uniform means for law firms to bill and insurance companies to evaluate their bills. Counsel Link is advertised as enabling companies to control your legal costs through enhanced billing compliance and greater understanding of your legal spending. Using natural language analysis instead of UTMBS codes, it catches discrepancies to your billing guidelines and helps you identify greater cost-saving opportunities. All of this might have an inside baseball quality to it. Indeed, keeping legal costs down helps keep premiums down. But there are two problems. First, in cases in which the insurance company hires an attorney to defend a policyholder in litigation arising out of an accident, the constraints imposed on the attorney may impinge the duties he owes to the policyholder. Second, it demonstrates how litigation management has taken hold to increase company profits at the expense of the policyholder, just like other elements of the claim process. Litigation management was part of McKinsey's early strategy for Allstate, and McKinsey made clear that The goal of defending a claim is not necessarily to win the particular case, but to maximize the company's profits. An August 8th, 1994 briefing was entitled Redesigning the Litigation Management Process to Enhance Allstate's Competitive Position. The value of enhanced organizational consistency and execution in litigation management was predicted to be between $275 million and $400 million after expenses. A key part of this process will be development of market-wide strategies to strengthen negotiation and litigation approaches. These strategies will include significantly higher levels of litigation to establish more consistent values. Allstate would contest more cases to set the bar lower for all claimants. For example, as discussed in Chapter 6, playing hardball with minor impact, soft tissue claims would produce higher levels of litigation over small claims. Although this strategy costs more in the short run, spending $10,000 to fight a $2,000 claim is not unusual. In the long run, it would increase profits, as claimants would be forced to take unfairly low offers because they knew that the expense of suing would exceed the reward. Under this approach to litigation management, the attorney to whom the litigation is referred is little more than a super adjuster, the next step in the process of claim resolution. The amount for which the attorney is authorized to settle the case is equal to the amount of the last offer the company adjuster made, even if that amount is lower than the Colossus evaluated amount, EA, at which the company might otherwise be willing to settle. The financial effects of this consistent strategy were measured in early tests. When the adjuster sets the parameters for settlement, and those are followed when the case goes to the attorney, there was on average $4,100 less deviation from the EA than before the litigation management measures were instituted. Cases that could not be resolved by the adjuster were referred to as DOLF, for Defense of Litigated Files. These cases had been investigated, evaluated, and negotiated already by the adjuster without a conclusion. The referral is only necessary because defense counsel provides the litigation expertise, according to McKinsey. The attorney's job, therefore, required consistently achieving evaluated amount, impacting market value to reduce loss payout, and maintaining tight cost control. Performing that job well would result in more trials, putting more policyholders and accident victims to the aggravation and expense of litigation to receive what they were owed. To carry out a consistent strategy in each case, the insurance company sets a plan and in many cases supervises the course of the litigation. Companies differ and classes of cases differ. In missed cases, for example, the attorney may follow guidelines set up by the company but will not require much hands-on supervision. In larger cases, the adjuster or litigation consultant may be more intimately involved in tactical decisions. Allstate's legal matter management and billing guidelines, for example, provided all work billed must conform to a litigation plan. The plan will be jointly developed at the commencement of a matter and revised and updated as appropriate. It should detail specific procedures to prepare the matter for trial or resolution. The plan will establish objectives, designate specific activities related to these objectives, and identify who will perform these procedures. Within the context of the litigation plan, specific advance approval was required for many of the normal steps in litigation, including preparing discovery or other motions, undertaking any major research project, retaining expert witnesses, preparing for trial, and taking an appeal. Other companies followed similar protocols. Progressive's claims standards dictate that each business unit must establish or adopt defense attorney standards applicable to all defense work performed in its jurisdiction. Progressive must be consulted before a motion or pleading other than a standard answer is filed, and claims management should be involved in all trial decisions. Lawyers sometimes express frustration or resignation at the degree of control exercised by insurance companies. One defense lawyer interviewed by Professor Herbert Kritzer bemoaned the changes in insurance defense practice over the last decade. Oh man, much more oversight by the insurance companies. Much more concern with the bottom line, much more control or attempt to control the case by the insurance companies rather than to rely on my judgment. I feel like I'm being second-guessed a lot more. And it's getting to the point where It's almost an adversarial relationship. Adversarial isn't the right word, but it's like the companies who are hiring us to do the best job for their insureds don't trust us enough to do the best job. They have to second guess what we're doing. 29 defense lawyers interviewed by Kritzer reported that the company's control often is without legal foundation or is ethically questionable. One company required its lawyer to refuse to turn over materials that it claimed was privileged, even though there was no doubt the plaintiff's lawyer could successfully bring a motion to compel the material's production.